Good morning, Honorable Chief Justice. Good morning, Honorable Justice of Appeal. Good morning, magistrates. On behalf of the Judicial Education Institute, I'd like to welcome you all to today's presentation on the proceeds of crime. Today, we have a very diverse array of speakers who will be joining us today on this very informative topic. Our first speaker is Mrs. Joanne Cuffy, who joins us from the National Center for State Courts of Barbados, who's going to lead us on a very informative presentation on cash forfeiture. So let us welcome Ms. Joanne Cuffy.
Good morning and thank you very much. I am happy to be here and I would like to adopt the protocol as established, except to say and to thank the Chief Justice for having me here and to thank every one of you for being here and to thank especially the person who nominated me, Clement Joseph. We worked together for a long time with the National Center for State Courts. Our office is, our field office is in Barbados and our head office is located in Washington. I work with Nicola. You may know her, she's the director of our program. And so I am here to do the most boring part of the program. And I'll tell you two things. One, I speak very quickly. And when I get excited about something, and this is an area that I'm excited about, and that you can stop me at any time if you have a question, and if there is anything that I say that you do not understand or you want clarification on. And the second thing is, I hope I don't bore you. So I will begin. And I will start with a simple case scenario. John sells coconuts and he owns a small bar. On May 12, 2024, the police had a reason to stop his car and to search it. In the car, hidden in the car, they found 200,000 euros. So law enforcement officers, you'll see me scratching their heads. What do we do with John? What do we do with the money? How do we proceed? And this is what this legislation does and does very well. It aids in where you go to and how do you proceed. Your legislation, Proceeds of Crime Ordinance, and if I make a mistake and say poker, it's because I'm used to the rest of the region where we use the Proceeds of Crime Act and not ordinance. So your Proceeds of Crime Ordinance and the amendment, the 2021 amendment, these are the legislations that we're concerned about today. Now, I want to tell you a little bit about the legislative aim. And Justice Blenman, as she then was, she's now Chief Justice of the court in Belize. As she then was, she said in the case of Daniel Ford et al., a case from St. Lucia, the Proceeds of Crime Amendment, Proceeds of Crime Amendment Acts are part of the legislative initiatives aimed at ensuring success in the fight against drug trafficking, corruption, and I would well add other predicate offenses, with the direct aim of allowing authorities to confiscate the proceeds of criminal activity. That succinctly clearly states the aim of the legislative regime, the Proceeds of Crime Act. Let us take the profit from crime. And so the legislation, POCO, seeks to deny criminals of the use of their ill-gotten gains, recover these proceeds of crime, disrupt and deter future behavior, because we believe that the less money they have to reinvest, then it will disrupt their criminal behavior. And that reinvestment is very important because that money that is seized, once it is criminal proceeds and it is seized, it is reinvested. And St. Lucia and Dominica have done really, really well in reinvesting these proceeds. So Dominica has, and I'll tell you, I love to tell that particular story. The day that they bought they used the proceeds of crime to buy scanners. And the day that they were testing the scanners, they found a huge shipment of guns and of firearms and ammunition. And so that is what the legislation seeks to do, put the money into the hands of law enforcement officers so that they can fight crime. Now, we know that in your constitution, I found the peaceful enjoyment of property and protection from deprivation of property. But we know that this is not, that there are exceptions to that. And your exception is contained in section 17 to A5. And nothing in any law or done under its authority shall be held to contravene, to the extent that the law in question makes provision for the interference with, taking of possession or acquisition of any property, right, or interest. And we know that property has been defined broadly by way of a penalty for breach of any law or forfeiture in consequence of a breach of any law. So when you look at the case of Ahmed Williams, which came out of Antigua from the Privy Council, you will see the court clearly articulating that, hey, criminal property, there is no right to criminal property. Now, under your POCO, section 106 of the ordinance permits, so the cash John has that is found, the officer is permitted, it was found hidden, the officer is permitted to seize it. So a police officer shall seize cash if he has reasonable grounds for suspecting that it is recoverable cash. One, it is either recoverable cash or part of the cash is recoverable and it is not reasonably practicable to seize only the part that is recoverable. After seizure is made by a police officer under this section, the police, or in the case of customs, shall promptly and in any event within 24 hours of the seizure, report the seizure to the Financial Intelligence Unit. Now, reporting it doesn't mean that the police cannot continue to hold it. What we do, and I should have told you at the beginning that I was a senior state attorney in the chambers of the Attorney General before going on to become the financial advisor with the Financial Crimes Office, that what we would do in terms of if the police sees cash and they want to hold it as an exhibit, we would carry out the financial investigation, and we would also, and in most of the times, file an application for seizure of cash, provided there are reasonable grounds for doing so, or to apply for a further detention. So one of the two we would do. So let me, and you'll see me go back to John's cash. It's 200,000 euros. When the cash was found, he was very angry with the police, and he told them, if I had a check, would you still seize it? Well, I do not know. I do not know I had cash. I did not know that I had cash in the car. So John is very upset. If I had a check, would you seize it? And the question is answered by section 2, which defines cash broadly to include notes of currency, any postal orders, checks of any kind, including traveler's check, banker's drafts, bearer bonds. That is critical in terms of the definition because it is broad. And I know in one jurisdiction, a check, which was the proceeds of crime, was seized. And the question at the time was, what do you do with it? And having failed to deposit the check, there was some issue with it, and then they had to go back to court in order to get that check deposited, because if you do not act fast, the criminal will empty the bank account and you will lose that check. So John's question is answered by that section. So when can cash lawfully be seized? Recoverable cash is defined by section 104, and to mean cash, recoverable cash, which is recoverable property. And you'll see me highlight that there. And I am going to go on to deal with recoverable property in terms of its definition. Or was intended by any person for use in unlawful conduct. So it is either recoverable or it was intended for use. It wasn't intended to use it to pay somebody, to off somebody. And the amount of cash is not less than the minimum. And your legislation makes provision for regulations to be made. I did not see this regulation, so I don't know. And you can help me, anybody can help me if you have a minimum amount that is set. Is there anybody that can assist me? Is there a minimum, has regulations been made?
Yes, the regulations are at the back of, good morning, Clement Joseph here. The regulations are at the back of the POCO and section 34. I have it here, section 34 C, tell you that the threshold for the purposes of section 101, which deals with cash forfeiture, the amount prescribed is $250, a measly $250, and it can be subject
to... because honestly, that frightened me, but I like the $200 and the $250. Thank you so much, Clement. Appreciate that. And so I move on to what is recoverable property. And your section 62 says that recoverable property is property obtained for unlawful conduct, and tainted properties is recoverable property. Property obtained for unlawful conduct that has been disposed of since it was obtained for unlawful conduct, or tainted property that has been disposed of since it became tainted property, is recoverable property if it is held by a person into whose hands it can be followed. I want to deal briefly. I did something wrong. I want to deal briefly with that, just that little last part, to following property into the hands of somebody it can be followed. You notice from that section that it protects the rights of third parties. Who do you think is somebody that you cannot follow recoverable property? You cannot follow it into their hands. Who do you think that person is being referred to? A third party? Anybody? I don't like talking to myself. Anybody? Who do you think it cannot be followed into their hands? Somebody who is... Does anybody want to answer? Clement, should I call on you again? Or should I call on somebody else? So...
Call on Magistrate Selva.
Okay, so Magistrate Seneca.
Selva.
Oh, Selva. Magistrate Selva, can you help me? Into whose hands can it not be followed? And we like equity.
Thank you very much, Clement, for that recommendation. Clement is a funny guy. So it's in my mind a person that comes to the transaction with clean hands, meaning there was a genuine purchase of an item in good faith. I would expect that person would not be subject to the forfeiture, but that's just off the top of my head. Yeah, it could be wrong.
Yeah, it's equities, darling. A bona fide purchaser for value without notice. So that's how third parties are protected under the legislation. Magistrate Silva, thank you very much. I appreciate that. And so we cannot follow it into a bona fide purchase. And I want to say upfront, this legislation is not designed to take legitimate property. If the property is legitimately owned, it is not designed to take it. And that's your role. Your role to decide whether it is indeed recoverable property, whether it was intended to be used in unlawful conduct. And I just want to deal with tainted property with a question again. Somebody, I own a car. Clement takes my car and he uses it to transport drugs. The police stop him and find the drugs in the car. One, can my car be seized? And two, under what condition can you not seize my car? And the first question is, my car can only be seized if I gave it to Clement knowing he was going to commit the offense. And it cannot be seized if I am an innocent party and I don't know and I did not give him any permission at all. And so these are the intricacies that we have to deal with, we pay attention to, and we understand. I want to acknowledge Justice Baptiste from the Court of Appeal, former Justice of Appeal from the Eastern Caribbean Supreme Court, and he dealt with a matter in which I appeared in along with the Solicitor General, and it is one of the matters that I will refer here today in terms of how the court dealt with it. Justice Baptiste, thank you for honoring us for your presence. Okay, so why the legislation? In this case, and I love this quotation, in this case, Aaron Richards, Lord Justice Tolson says, the underlying purpose of the provisions of the Act is plain. No self-respecting organized criminal would expect to be caught with high-value property in his own name, readily identifiable, particularly since the enactment of legislation which is designed to strip criminals of their profit. As a matter of standard practice, is likely to have taken steps to transfer these high-value items to offshore trusts and all of this. And so we have to look carefully at who, in terms of John, is it his property? Is he holding it for somebody? We have to look at all of the nitty-gritties to determine whether that property is recoverable. What do we mean? The second limb of it is unlawful conduct. What is meant by unlawful conduct? And Section 60 of the legislation states unlawful conduct is conduct which, A, if it occurs in the islands, is unlawful under the criminal law of the islands, or if it occurs in a country outside the islands, is unlawful under the criminal law of that country. And if it occurred in the islands, would be unlawful under the criminal law of the islands. And so you look at the unlawful conduct, and in the case of Joanna Gage and the Attorney General, the court dealt with what do you look at when you're looking at unlawful conduct. And so we have to ask two questions for John's 200,000 euro. Is it recoverable property? Do we know enough to determine that it is recoverable property? And can it be lawfully seized? And can it be lawfully detained? And these are the questions that you will grapple with as you go along and you look at the cash. And then we will come, and I am not done with John. John's scenario is the thread through which I take you through this presentation. And you will see that the prosecutors would have to present you with the circumstances. I want to point out here that the standard of proof that you are to deal with this cases on is on a balance of probability, and the matters you have to see whether it is proved that any matters alleged constitute an unlawful conduct. Is it unlawful conduct under the laws in any of the islands? Person intended to use the cash in unlawful conduct, or a person used or intended to use any property in or in connection with the unlawful conduct. Good. Any questions so far? Anybody? Okay, so we're dealing with search under Section 107. A law enforcement officer being lawfully on any premises and having reasonable grounds for suspecting that there is recoverable cash on the premises may search for recoverable cash. Where he suspects a person is carrying recoverable cash, he may require the person to permit a search of the article he has with him and require the person to permit a search of his person, and in exercising this power, he may detain the person for so long as is necessary. No, because reasonable grounds run through the application of your duty in terms of deciding whether the cash is recoverable. You have to do, or you have to grant a further detention. It has to be reasonable, on reasonable grounds. I want to recommend to you, sorry, the case of Assets Recovery Agency Jamaica Proceeds of Crime Customer Information Order 2015 UKPC number 1. And in that case, the court was dealing with reasonable grounds for believing, and you will see the low threshold. You will see the low threshold that applies. Sorry, I just thought something came up. You will see Clement put a comment in the chat saying that police put in the definition of who a police officer, law enforcement officer is. So I will get back to the test. And you will see in that case that the court was dealing with reasonable grounds for believing. And you will see the low threshold. And the court stated that the test is concerned not with proof, but with the existence of grounds, reasons for believing, thinking, suspecting something, and the reasonableness of these grounds. And so what we'll normally do is in one of the paragraphs, so we set out all the grounds on which we're either applying for forfeiture or further detention, so that it focuses your attention. Where was the cash? Where did John have the cash? We said it was hidden. Are there any other factors that we need to look at? You look at the currency. You look. So does TCI use euro? Do they use US? Is it a currency that is readily available? And you look at the person. Can they would he have gotten 200,000 euro from selling coconuts or from his small bar? So these are the factors that you would have to consider in order to determine whether the grounds are reasonable. And so I move on now to seizure. And again, reasonable grounds for suspecting. A police officer shall seize cash if he has reasonable grounds for suspecting that it is recoverable cash. And so it takes you back to your definition of recoverable cash, or part of the cash, and it is not reasonably practicable to seize only that part. Okay, so seizure under section 107, I want to recommend to you the case of Magistrate Reynolds and the FIA. It's a St. Lucian case. It was decided in April 2024. A seizure of cash done, which is not on the POCO, is not subject to the rules of detention under section 107. You will see as we go along how important that point is in terms when we deal with re-seizure, in terms of what is the concept that is in the legislation. The next point is the police officer does not need to seek a further detention after 72 hours if it is not under POCA. And sometimes what law enforcement officers would do is that the police would hold it for investigations. So the criminal department, so for example, drug squad or CID, or if it is called customs, so they will hold it either for a customs breach of the Customs Act, or drug related crime as evidence, and that would give the FIU, the Financial Intelligence Unit, time to investigate the origin of that cash. And so also that case also makes it clear when you can reseize, and so I would recommend it to you. Now, so once cash is seized, cash can be detained for 72 hours. Okay, now the court has interpreted that 72 hours very strictly. The court will tell you if you are outside of the 72 hours and you have not obtained the order, and it's not just taking it and filing it with the court, it is obtaining the order. And I want to do, there are two cases that you can read that will help you with this. And the first one is the Chief Constable of Merseyside Police and Hickman and another, 2006 EWHC 451. Now, it is interesting to note that the common law position was that once, if you did not have criminal proceedings, you do not have a reason to hold it under a legislation for a criminal proceedings, you could not hold the cash. You couldn't hold a personal property. So the proceeds of crime changed that law, changed that position, and allowed you to hold it to investigate the origin of the cash where you have reasonable grounds to show that it is the proceeds of crime. And so that is the starting point of the 72 hours and the strict adherence to the 72 hours. And you must obtain the order within that 72 hours, or else there is no, you have no legal grounds for holding the cash. And I want to explore with you, I will explore with you a case that happened during COVID, and it was quite interesting what the court did there. And under Section 107, where cash is seized and the officer continues to have reasonable grounds for his belief, he may detain it for 72 hours. I've told you that. The magistrate must be satisfied that there are reasonable grounds. And I am re-emphasizing this because it is important. The magistrate must be satisfied that he has reasonable grounds for suspecting that the cash is recoverable or that it is intended for use in unlawful conduct. Now, the point here is, can the magistrate say, I am not sure about this, I'm gonna put this matter and deliberate on it, not grant the order, and wait for another week? No, the magistrate can't. The magistrate must grant that order or refuse that order within that 72 hours. If for any reason the order is not granted within the 72 hours, can you still recover that cash? No, you have to give back the cash. And it happened to me early on in my dealing with cases in that area. We had seized it was a lot of cash, $60,000 US from this guy. He had it concealed in the pocket of a bus. He had wet clothes in the bus. He could not explain. He gave several reasons why he had the 60,000 US, sorry. And so we had, I'm saying all of this to tell you we had a very good case, and he was known to law enforcement officers, and that is why they had stopped his vehicle on that day. And we missed. We applied for the order, and the court, and it was filed. The application was before the court, but it was not granted within the 72 hours. And guess what happened? His lawyer spotted it. It was early on. His lawyer spotted it, and so we had to return the cash. At one time, in terms of the cash, in terms of not having obtained the order, the attorney agreed to grant an extension of time. And I am still in my mind wondering if that in itself was lawful. So the further detention of cash, the continued detention is justified, has to be justified, because it is for further investigation or consideration is given to bring in proceedings, whether within or outside of TCI. Proceedings against that person for an offense with the cash is connected, with which the cash is connected, have been started and have not been concluded. And so you have to justify the further detention. And so the officers will come. First time you may give them the first 3 months, but when they come back, is it justified? Are there reasonable grounds? And what have they done within that 3 months to continue to the further detention, the order for further detention? Would you grant it if there is nothing new, if there is nothing more? And so we, when we train law enforcement officers, tell them that they have to carry on the investigation, and it is on the, and you will understand that if an officer has to apply for an MLAT, like we had to in one of our cases, and it took a very long time. It took almost 8 months for us to get the information back because it was in the Netherlands and we needed to get the information before we could proceed. And there was another one and from the French authorities, and they took a very long time. And so our 2 years did not expire, but we got close to it. And yes, we continued to get the further detention because we had sent out the MLAT, and within that time, there were other things that were being done. Okay, so we go back to Johnny's story and an application for further detention. So the money had been discovered in the glove compartment of his car. At first, Johnny told the police that he was not aware that the cash was there and he did not know anything about it. Later, later at the police station, John claimed that it belonged to a friend who had borrowed his car for 2 days, and that the friend had forgotten, who had borrowed his car, sorry, 2 days ago, and the friend had forgotten it there. He also told them that he got it from the sales of his bar and his coconuts. And there are cases on lies and stories told by the defendant, and whether these establish reasonable grounds. So an application is made for further detention of the cash. And the question is, would you grant the order? And in those circumstances, there are reasonable grounds to allowing the investigation, because they would have to determine whether the cash actually came from his businesses, whether he makes that cash. And we had one case where the man was really a coconut salesman, and he was caught with 8,000 euro, and they were all 100 notes, they were in series. And he said that he had been, when his customers came in, he would change the smaller notes into big notes. But why were they in a series? And the reason why the police had stopped the car is because they suspect that he was going to change money for a drug dealer, a well-known drug dealer that we had seized close to €500,000 from. And so these are the grounds that they will set out nicely, the prosecutors will set out nicely in a paragraph for you, so that you know what you're considering. Further detention, I cannot overemphasize the fact that it must be laid within the 72 hours. That means that the police does not have the authority to detain the cash beyond the 72 hours. And the order of the court must be for a period not exceeding 3 months, or in the case of further applications, not to exceed a total aggregate of 2 years. And that is similar for most of the legislation in the region. The further detention is critical, and I know that one of my colleagues will be dealing with further detention, and so I do not want to spend much time on it. I want to recommend this case that I haven't read to you. It's an interesting case about the application for further detention and how strictly the court considered it. And it's Commissioners of HMR and MAN 2021, EWHC 1182, admin in bracket. And in that case, the application for the continued detention of the cash had been filed, and it was before the court, and it had been filed on time, before the 48 hours that the UK has. that the delay had been caused by the pandemic, and the commissioners had done all in their power to get a date for the hearing, and the delay was not caused by them. And guess what? The court still decided that the detention of the cash was unlawful, that they couldn't grant the order for further detention. I just want to, as I wrap up, I want to recap by pointing out the sections of the legislation. Search and seizure under section 101, 105, and 106. Your first application for detention is under section 107. Further detention is 107 as well. Applications for, and so somebody can apply to release the cash, and you can have an application for forfeiture. In circumstances where we had a difficulty, so Dominica has cash detention rules, and there was a difficulty with the rules. So what we would do is to file an application for forfeiture sometimes, and never file the application for detention. But even if you do not have rules, I want to point out to you that you can file an application for forfeiture without filing an application for further detention if you have sufficient information. And so you would have pretrial review, and then you have, if the cash is forfeited, you would have hearing for appeals, and all of that is in your legislation. Now, prosecutors should bring to the attention of the court, to bring to the attention of the court that the continued detention is justified while they are investigating the origin of the cash. Consideration is given to the institution instituting criminal proceedings against the person, and they must set out the grounds for the detention of the cash, so that for your consideration. I wish to thank you for listening to me, and if you have any questions, I am happy to answer them.
Hi, good morning, Ms. Xavier Cuffy.
Thank you.
Thank you very much for that very informative presentation. So I'll now open the floor up for questions from the honorable judges and magistrates. So thank you.
Okay, thank you, everyone. I know I could not have been that good, so maybe you are just tired of me.
No, you
Thank
were
you
very
so much.
clear,
I
ma'am.
appreciate it. Oh, thank you so much.
My sister, thank you very much for that very thorough presentation. I'm seeing one question. No, it was a comment in related to where an application for the forfeiture of any cash is made under this section, the cash is to be detained. Okay, so it's a section of the act that is cited by Mr. Joseph. So Ms. Xavier Cuffy, thank you very much for that presentation. And we have just about 5 minutes before our next two presenters, Ms. Kisha Sutherland and Mr. Alan Alexander. I believe Ms. Sutherland is here. Hi, good morning, Ms. Sutherland.
Hi, good morning to you.
Would you mind if we go directly into your presentation?
No problem. I will not be sharing though. Mr. Allen, can you share the presentation, please?
Thank you.
Do we have the requisite permissions to share?
Yes.
Come on, share the screen. Good day, can you see me? Yeah.
Yes, good morning, Ms. Alexander. We can see you.
Please be a little patient while I just try to share the screen. Good morning to all.
Good morning. Good morning.
Right, so while Mr. Alexander is setting up, I'd remind the honorable judges that Ms. Kisha Sutherland and Mr. Alan Alexander are joining us from the Asset Recovery Unit of RSS Systems in Barbados. So Regional Security Services of Barbados. So thank you very much, and we look forward to your presentation. We can see the PowerPoint, Mr. Alexander.
Okay, pleasant good morning to everyone. I take this opportunity to say a special thank you for the invite to the Regional Security System to present today before this honorable and distinguished audience. I have with me today, my name is Miss Kisha Sutherland. I am the Director of the Asset Recovery Unit, and I have with me today Mr. Alexander. He is a legal advisor, also of the Asset Recovery Unit. Okay. So I think we can go right into the presentation.
Yes, certainly. Thank you very much.
Yes. Okay, so the Regional Security System Asset Recovery Unit, just a little bit about what we do. We are based here in Barbados, and we represent 9 countries, including the 6 OECS states, Guyana, and Barbados. The role of the Asset Recovery Unit really takes on what I consider to be 3 substantial prongs. One which relates to the standardization, first the development as well as the standardization of legislation. So having the most updated pieces of tools to address and combat transnational organized crime, utilizing financial investigations and asset recovery. It requires that we have broad and a broad legislative framework, as well as flexible legislation that adapts to the trends and the methodologies that are being utilized by the criminal enterprises. We also do mentoring and training, and substantively, our training often is practical and bespoke to our member states, and it includes training persons from the point of recruitment right up to sensitization for the judiciary and the magistrates. And most recently, we have taken on the responsibility of looking at the gaps within our member states' compliance and seeking to address said gaps and their priority actions to ensure that they have the highest level of compliance. And we hope that with the combination of these 3 fundamental functions, we will be able to take the profit from crime, we will be able to address significantly issues as it relates to transnational organized crime and other serious crime in the member states by hitting the criminals where they will most feel it in their pockets. Next slide, please. So this presentation that we are doing today in relation to the seizure, the phase, that particular phase as it relates to cash seizure, we recognize that cash seizure in of itself has several phases, and we are very grateful for Mrs. Xavier Cuffy for outlining some of what we consider to be that the framework under which the cash seizure provisions or the cash summary provisions under your proceeds of crime ordinance work. Now, understanding that cash seizure has different phases, we are going to, we have the task of looking at what we consider the initial phases. And we hope that we can look at understanding, examining and understanding the purpose of the seizure provisions and look within that context to really explore what is the different jurisprudence in the area, but as well look at the practical realities, right? So we will examine in the processes. We will look at what are some of the examples that we've seen across the countries as well to help in terms of assisting the court in terms of the interpretation, as well as I said earlier, the practical realities that we would have been seeing working along with the criminal justice practitioners in this particular area. And hopefully we are also able, at the end of this presentation, to provide some form of examination as it relates to the processes, right? Next slide, please. Okay, so as I said earlier, these are some of the objectives: examining the who, what, and how of cash seizure, examining the conditions precedent for cash seizure in civil cases, as well as looking at the processes and determining what is really supposed to happen at the seizure phase and as well as that initial detention phase. Okay, so for the interest of time, we will not look at the case study because we realized there was another type example that was presented. So we will skip the case study and we will go right into the presentation. Mr. Allen, if you can change the slide, please. Right. So I will, at this point, I will leave you here with Mr. Allen, who will go into what is cash, the discovery of cash, who may seize cash, and give you a general overview of the civil cash seizure provisions. We do understand also that Mrs. Xavier Cuffy would have looked at some of these aspects. So we would only look at them to the extent that they are necessary for the provisions that comes later in relation to our explanation. So Mr. Alan, you could take it from here, please.
Thank you very much.
Thank you very much, Ms. Sutherland. Ms. Sutherland is my director at the ARU. Welcome. Good day to all. I am a legal advisor at the Asset Recovery Unit. I was also a detective criminal investigator at the Criminal Investigations Department, Jamaica Police Force, for the past 10 years. So part one of the presentation, we'll be looking at what is cash, the discovery of cash, who may seize cash, a brief overview of cash seizure in civil recovery. So the cash seizure provisions are provided for under section 106 of the Proceeds of Crime Ordinance, which states that a police officer may seize cash if he has reasonable grounds for suspecting that it is recoverable cash, or that part of the cash is recoverable cash, and it is not reasonably practicable to seize only that part of it. So cash under the ordinance is defined in section 2.1, the interpretation section, which says that it includes notes, coins, and any currency, postal orders, checks of any kinds, travelers' checks, bankers' drafts, bearer bonds, and bearer shares, and any kind of prescribed monetary instrument. One may wonder whether virtual assets such as cryptocurrency may form part of that definition of cash under section 2 of the ordinance. Common law has stated that these virtual assets are to be regarded as property. In one of the cases, UK cases, that's AA versus Persons Unknown, the court held, the Queen's Bench Division held that Bitcoin constituted property which is capable of being subject to an improprietary injunction, a freezing order. A further case, DPP versus Bress, also held that cryptocurrency or crypto assets, which fell within the wide definition of property under the POCA, which states that it is intangible, other intangible or property. So cryptocurrency or virtual assets fell within that, that class of property. We have a mirrored section in the Proceeds of Crime Ordinance, section 3.1c, which includes other intangible property. So virtual assets should fall under that provision in POCA. So for the purpose of the ordinance, virtual assets would not form or would not be regarded as cash. Sorry. So who may seize cash? Under the ordinance, section 106 says a police officer. According to section 2, the interpretation section, it defines a police officer to also include a custom officer. And that is further supported by section 106.2, which mandates the reporting of the cash seizure to the Financial Investigation Unit or authority or agency in the islands. It says that the senior customs officer should be the one reporting. So that further supports the notion that a custom officer is also regarded as a police officer under the ordinance. So some key features about cash seizure proceedings. In the course of their work, law enforcement officers may apply or may probably come upon cash which is connected to criminal activity. Also, cash can be seized under the ordinance as seen in section 106. This is the first independent stage, as my director initially stated, of the civil recovery procedure of forfeiture proceedings for cash. And it is governed by part 3 of the ordinance, which is titled civil recovery. So cash seizure for civil recovery can take place either concurrently or in place of criminal investigations. And civil recovery proceedings are in rem proceedings, meaning that the proceedings are against the cash and not the person. Therefore, the cash is the defendant, and there's no requirement for a conviction against the person in order to forfeit that cash. Instead, the guilt is assigned to the cash, and the person would have to disprove the case which is made by the prosecution. Right, so cash may be seized and detained even if the person was not criminally charged, as mentioned earlier. Before the enactment of the POCO, in criminal proceedings, forfeiture applications will only be entertained where the person was convicted for the offense that was charged. And where the person was acquitted or the matter was discontinued for some reason, under the common law, the item would have to be returned to the property, to the person. So that person was entitled to the return of the property, and that was so even if the cash represented proceeds of crime. And this point was succinctly made clear in the case of Webb. But Parliament changed that position by enacting the Proceeds of Crime Ordinance as amended. And under Part 3 of the ordinance, labeled Civil Recovery, the police and custom officers were entitled to now seize the recovery with cash without charging criminally. The standard of proof in these instances is on a balance of probabilities, that it is more likely than not that the facts alleged have occurred. And section 60, subsection 2 of the ordinance makes provision for the standard of proof. How is cash discovered for civil proceedings? Section 105 of the ordinance, titled Searches, indicates that a police officer who is lawfully on any premises and who has any reasonable grounds for suspecting that there is recoverable cash on the premises may search for the cash there. And if that police officer has reasonable grounds for suspecting that the person is carrying recoverable cash, he may request the person to permit a search of any article that the person has, or to search the person of that individual. And he may detain the suspect for as long as it is necessary to exercise that power. That section does not require the person to submit to an intimate search. And in these instances, the officer needs approval from a senior officer. Where the prior approval is not obtained, if cash was not seized, or if cash was seized and it was released before 48 hours, you would have to write a written report to the senior officer stating that the seizure was reasonably practicable to perform the search and the powers were exercisable in the circumstances. So the discovery of cash Section 105 indicates that the police officer has to be lawfully on the premises. So how should a person lawfully be on the premises? We know that an individual police officer can be lawfully on a premises with the strength of a warrant. Some provisions, like the immigration ordinance, specify that searches can be done without a warrant. So in these instances, if a police officer is invited to a search on the strength of, on the basis of immigration investigations, then he would be entering the premises lawfully in that regard. Otherwise, he may be entering on the premises, he may only enter the premises on the strength of a warrant, a search warrant. You do not need a search warrant to search a person of a person, the person of an individual, sorry, or any article that the individual has. Where the search is illegal, or where the search was not made on the strength of a warrant, it may be deemed illegal. And the effect would be that the search, the seizure, or the detention would be unlawful, springing from the unlawful search. And in the case of Cook, the court suggested that in these circumstances, that could be lawfully corrected by seeking and obtaining a further warrant from the judge or magistrate. Otherwise, the seized good should be returned to the person from whom it was seized, and then it should be lawfully reseized. However, if the seizure, the unlawful seizure, was not challenged in the seizure proceedings, or the detention proceedings, and it is challenged in forfeiture proceedings, the court would not be concerned about the illegality of the search in the forfeiture proceedings. And the case of Stongsell establishes that there is no doctrine in cases concerning forfeiture of cash, denying the authorities the fruits of the forbidden tree, unless the relevant statutory regime made the forfeiture of the cash dependent on the cash having been lawfully seized and detained in the first place. So the unlawful seizure would only have an impact on the initial cash seizure proceedings, that is, if the seizure was challenged, or the detention proceedings, but it would have no bearing on the forfeiture proceedings, in a nutshell. However, going back to that, we're not saying that or upholding unlawful searches. We're saying that if the search is unlawful, based on the case of Cook, the officer would have to return the cash to the person briefly and then conduct a reseizure. Please bear with me for a minute because my battery is dying. Let me just connect my charger.
Yes, thank you.
So part 2 of this presentation deals with seizure and reseizure and the grounds. So Section 106 deals with seizure, and I already read Section 106 at the beginning, that the police officer may seize cash if he has reasonable grounds for suspecting that it is recoverable cash, or only part of that cash is recoverable, and it was not reasonable practicable to seize only that part of it. Section 106 basically stipulates the conditions precedent for cash seizure. And these conditions would also be necessary for further detention. When we get to that bridge, we'll cross it. So what is recoverable cash? Because the police officer can seize cash if it is recoverable cash, or if part of the cash is recoverable. So according to Section 104 of POCA, recoverable cash is defined as recoverable property or tainted property. Now, recoverable property, according to POCA, Section 61, is property that was either obtained or retained, or obtained by, or in return for unlawful conduct. And tainted property defined in section 59(3) of COCA is that it was used, means that the property was used in or in connection with unlawful conduct. Now, section 104 goes on to say that, or it was intended by the person for use in unlawful conduct. So that is another condition precedent, that it was either recoverable property or tainted property, in that it was obtained by, or in return of unlawful conduct. It was used in or in connection with unlawful conduct, that's tainted property, or it was intended by any person for use in unlawful conduct. And that amount of cash is not less than the minimum amount, which was also established in section 104, which states what is recoverable cash. So according to the subsidiary legislation of the ordinance, section 34D stipulates that the minimum amount is, the prescribed minimum amount is $250. And another condition precedent is where there are reasonable grounds for suspecting that only part of that cash is recoverable cash, which the aforementioned would apply, it is not reasonably practicable to seize only that part of it. So the threshold is reasonable grounds for suspecting, as indicated in section 106, that the police officer can only seize the cash if he has reasonable grounds to suspect that it is recoverable cash. So to understand what is meant by the term suspecting, reasonable grounds for suspecting, we must first understand what is suspecting. Now, the threshold for suspecting is not the same as the threshold for reasonable grounds for suspecting. But in simply understanding what suspecting means, the case of Da Silva indicates that the term suspecting, as without more, it implies that there's a possibility, a mere possibility that was more than fanciful, that the relevant facts existed. Now, where the act stipulates or requires reasonable grounds, the threshold is a lot higher. And to determine what would be among the reasonable grounds to suspect, the case of O'Hara established that a two-pronged test is necessary. Now, that two-pronged test is part subjective and part objective. This test relates to entirely what is on the arresting officer's mind when he exercises the power to seize. So the subjective element would be that he must have formed a genuine suspicion in his own mind that the relevant facts existed. And the objective element is one where you have to prove the reasonable grounds for his suspicion, which he had formed. The application of the objective test does not require the court to look beyond what was in that arresting officer's mind. Instead, the relevant question would be whether a reasonable man would be of that opinion, having regard to the information which was in the mind of the arresting officer. And that opinion would be that the cash is recoverable cash. So the source and the context of the information that had been determined by the officer, it would establish reasonable grounds. And the officer's suspicion, as I mentioned earlier, does not need to be based on any outside factors, but based on his own observation. And that could be based on what he has been told once he forms that genuine suspicion in his own mind. And the court does not have to prove that information. All the court has to be satisfied is that he formed the genuine suspicion. So some examples of reasonable grounds for suspecting would be include information that is received from credible sources, if the individual is known to the police, if he had to be involved in illegal activity, whether he has previous convictions or acquittals. Now, an important caveat here is that the previous unspent convictions, that is, and acquittals, they must be of a similar nature to the unlawful conduct that is being alleged to be linked to the cash. This would indicate that the person is known for a particular criminal lifestyle, which are similar to the circumstances of the seizure. The cases of Ali Bess and HM Customs would indicate that. If the individual behaves suspiciously or he tries to flee from the police, that would amount to reasonable grounds. His traveling patterns, if it don't match his level of economic activity. If he lives a luxury lifestyle, I'm not going to read the entire list because I'm sure that some persons could follow. So I'll just pick out from the list. If the cash was found among illegal goods, or if there are discrepancies between more than one with suspects between the responses, that would also amount to reasonable grounds for suspecting. That is similar to inconsistencies regarding the answers that is given by a person. And the case of Monica stipulates that. So in Monica, the court held that an explanation from a customs and excise official that there was no proper explanation in supporting documentation as to the source of cash or as to why the banking system had not been relied on, it was accepted as reasonable. So all his explanations given were inconsistent. Lies would also amount to reasonable grounds. And Justice Sedley, in the case of Nevin and Customs, indicated that a suspect who gives an account of his reasons for carrying money, which the justices reject as untruthful, cannot complain if the justices want to infer from other relevant evidence that by itself might not have been enough to satisfy them that the true reason was for use of drug trafficking. So lies can be used to make the necessary inference. That's what the case basically says in a nutshell. Admissions would amount to reasonable grounds as well, and silence during a civil interview. Because cash seizure proceedings are civil proceedings. So whereas silence may be held or may be deemed prejudicial in a criminal proceedings, because the preconditions for the portion, the judge's rule portion, are not necessarily met in a civil interview, that will not be prejudicial for the to the defendant, because as we indicated, the cash seizure proceedings are in rem and not necessarily in persona. So the liability does not attach to the individual, but to the cash. So it will not be prejudicial to the person. It will only be against the cash. So silence can be used to draw the necessary inference. Now, what is the weight of the reasonable grounds? The case of Dover stipulates that what is necessary is that the courts consider whether a prima facie case is made. So once the court, in its opinion, is of the view that a prima facie case has been made, then the reasonable grounds requirement has been met. And that is what Dover establishes in a nutshell. So now we look at the seizure of cash. So according to the case of Hickman, cash may be reseized, and it may be reseized where it was seized initially or originally under a first statutory power. So if the customs officer initially seizes cash under the customs ordinance in the islands, or a police officer seizes cash for police investigations under any statutory power in the islands, making provisions for the seizure of the cash, which would be the theft ordinance, police ordinance, any other ordinance, which makes provision for the seizure, then cash can be reseized under the proceeds of crime ordinance. So Hickman basically stipulates that. Now the conditions for reseizure are that the first seizure must be lawful as I already mentioned in Cook. And if the seizure was not lawful, that original seizure, if it was not lawful, as I already indicated, the seizing officer would have to correct the unlawful seizure by either applying for and obtaining a further warrant, or returning the cash to the individual briefly and conducting a re-seizure. Now, Hickman indicates also that the cash can be received from a police officer at the police station. So just as a seizure can take place after an arrest at the station, so too can cash be seized from the police at the station. So once the cash was originally seized lawfully according to Cook, if the police still have possession of that cash at the station, then it is not necessary to return the cash to the individual to then effect the re-seizure. You could conduct the re-seizure from the police officer at the station, and once you serve the relevant notice. And that is what the authority of Hickman establishes. Another condition is that it must be done within a reasonable time. Now, the case of Iqbal and Goff indicates that there should be time for the police officer to consider whether they are able to defend the civil proceedings if the cash is returned, or time for the officer to consider whether to seize the cash, or whether to organize the return of cash if it's appropriate. So that is basically a grace period to return the cash following the discontinuance or an acquittal of the defendant. The St. Lucian case of Peter Hippolyte also establishes that, but I will touch a bit more on the case of Peter Hippolyte, as it seems to suggest that we're heading towards a new jurisprudence in that area, because the case of Iqbal and Goff were cases that applied the PACE provisions, which we do not have in the Caribbean. Now, in looking at the case of Peter Hippolyte, which I'll touch on in a while, and the case of Iqbal, in Iqbal, the period of time which was challenged was 7 days. And in the case of Peter Hippolyte, the period of time was 4 months. In both instances, that is the Court of Appeal decision of Peter Hippolyte, that is, and the case of Iqbal, the court held in both instances that the time was reasonable. Now, the case of Iqbal suggests that the reasonable time must be short, but the case of Hippolyte stipulates that the question of what is reasonable time is a question of fact, and this is determined on a case-by-case basis, because the court will have to look at the principles of necessity and reasonableness, which are principles that are grounded in common law. And that is, in as much as we do not apply the PACE provisions, but the PACE provisions basically codified common law principles. So these principles, which are the principles of necessity and reasonableness, are principles that are grounded in common law. And also the principle of good police practices, which balances the powers and the rights, the rights and the individuals, the rights of the individuals, against the welfare of the public. So the cases, if courts in our jurisdiction apply cases which apply the PACE provision, the case of Peter Hippolyte says that we are not giving application to the PACE provisions, but we are basically applying grounded common law principles. And what would amount to reasonableness would be on a case-by-case basis as a result. Because what would amount to reasonableness in a 7-day period may not necessarily be what would be reasonable in a 4-month period. The case of Peter Hippolyte also indicates another provision for another condition, for re-seizure, which is the officer must have form the reasonable grounds to reseize at that time. So the section 106 provisions still apply for reseizure as they apply for seizure. So the officer must formulate the genuine suspicion that there are reasonable grounds to suspect that the cash was recoverable cash for him or her to receive. So I will hand back to my director to present on part 3, which is initial detention.
So thank you very much, Mr. Alexander.
Most welcome.
Next slide. Okay, so we have looked at the searches. We have looked at the searches, and we have also to some extent looked at seizure. One of the things that I think we also want to add in terms of, you know, this awareness session is really to highlight that seizure itself is a factual. And what we recognize as a team going through most of the jurisprudence that we've benefit from, whether it is from the UK courts or from our own Caribbean jurisprudence, we've recognized that that is the team that goes right through the cases, is that it's gonna depend on factual circumstances. There is one thing for sure that is not necessarily dependent on factual circumstances, and we will get there when we talk about time. But when it comes to seizure, the seizure is always an issue of what actually happened in a particular case. And so, as Mr. Alexander would have said earlier, it will really be determined on a case-by-case basis. Now, when we are looking at seizure, we must always recognize that seizure, because it is factual, it also can be to some extent implicit. And this was the principle that came out of Catherine Walsh based on actions, right? So in this Catherine Walsh case, what we had is a situation where you had a customs officer seizing, and the customs officer basically told the person from whom they seized the cash that you can leave, but you will not get back the cash. They had not at that point said that, you know, they are seizing the cash. But what the court found is that when they had exercised control over the cash to the point that they had told the individual from whom they seized the cash that they could leave, but they will not get back the cash, they must have formulated the reasonable grounds necessary at that time. And so when they exercised that type of control, seizure was implicit by their actions, even though they would not have seized the cash officially until later on. So in the counting of the time, what the court did was to actually went back when the customs officer would have actually given the oral representation to the person that you can leave, and however you will not be getting back the cash. And so when seizure actually occurs, will always be factual, and is always something to be determined based on the evidence before you on the affidavit of the seizing officer. I am sorry for the typo. Thank you. Now, when we are looking at initial detention, the initial detention period, one of the things that we are often grappled with is what should the investigator or the seizing officer be doing within that time, and what is considered to be reasonable within that period of time. Now, there's another presentation on further detention, so I'm not necessarily going to speak about that. But within that 72-hour period, as established under Section 106, what is it that is required or considered to be reasonable? It is reasonable for the officer to at least make some type of what we consider follow-up, right? So must have done some follow-up or some inquiries about the story if one was given by the respondent. The investigator should also, as the legislation specifically says, seek to report the seizure to the FIA. And that would therefore mean that more than likely the FIA is the one with responsibility who's going to be bringing the seizure. You would expect as well, as a judiciary, that they would have done some interviews, at least with 1 or 2 persons, if it's possible. Now, it may not always be practicable because we do have cases where you have respondents that are very evasive and they will take every action along with counsel's advice, to make sure that they're evading and, you know, as it is civil in terms of the interview, they will, if we go down that road, they could also decide not to subject themselves to an interview. Now, oftentimes, we have had some issues in some of our countries, the countries that we would have advised, where there is this mistaken notion that you need to do an initial detention prior to a forfeiture. But the legislation and the cases have made it very, very clear that a forfeiture can also happen within that initial detention period. Now, sometimes in some cases, you have respondents who will clearly say upfront, look, I got these funds from drug trafficking, or I got these funds from some illegality. And where they did that, that's an admission. And if it's an admission that they would have committed a crime, as outlined by Mrs. Xavier Cuffy earlier, that will amount to unlawful conduct. And as such, you would have had the requisite evidence to some extent to show that these funds came from a particular crime. And so a Section 110 application for forfeiture can actually be made within that initial detention period as well. Next slide, please. Now, when we are looking at the provision, this is what it states specifically. And I want to go a little further and look within that initial detention period at the 72 hours and what is considered by the courts when they are looking at time, because we have also seen some misapplication as it relates to time across some of our jurisdictions when they are interpreting this particular section as it would have been expressed in their respective legislation. Next slide, please. Now, when we, as I said earlier, in terms of the initial detention, we looked at the when it starts, so we don't need to really go into this slide, but in Oxbridge, which is a case that really looked at, I think, one of the first seminal cases that look at time and how you are to interpret the time, the statutory limits within the proceeds of crime legislation. The court was very, very clear that seizure will start where you have established initial control, effective control, and implicit in your effective control is the fact that you would have formulated the reasons, and therefore you would have substantially been in a position to seize the cash, though you may not have said it explicitly. Because in these type of matters, the court stands as the arbiter of justice, and therefore it must look to some extent to ensure that the individual rights of the person as it relates to property is not hindered in any way in a very, what we call, arbitrary way, right? Next slide. Now, so when we look at the initial detention, we saw that, you know, these are the conditions precedent that the cash needed to have came from unlawful conduct, or it is connected to unlawful conduct in some way, or is intended to be used by the person in unlawful conduct. And we see that you have a minimum amount. Now, while we do not have the case here as it relates to minimum amount, and your minimum amount is very, very low, what the court has said previously is that when you are stipulating, when you're interpreting what is the minimum amount, there are situations where if you seize cash from several persons, right? And it might be $100 from one, from A, $100 from B, and $50 from C. If it can be proven that there is interconnectedness between A, B, and C, then in those type of cases, you still will be able to seize the cash, though the minimum amount may not have come from one particular person, but rather from three different persons. Next slide, please. Now, in the case of Oxbridge, the court was very clear when it came to time. So during the initial detention period, time is of essence. And in the case of Oxbridge, basically, you know, it was a situation, it is law enforcement, there was a mistake. We are all human beings, and sometimes you do have situations where, you know, the cases are not, the circumstances doesn't always allow for you to get to the court within that 72-hour period. And then they had a situation, very understandable situation in Oxbridge. However, despite the court understanding the circumstances of the officer and why that particular matter had came to the court out of time, the court said that, look, when we are looking at the time period in these provisions, because they are considered to be draconian, it is going to be strictly interpreted, right? So in these circumstances, the court found that 72 hours is literally 72 hours. And then when we look at the Catherine Walsh principle, we saw that when the court stipulates, when the legislation, stipulates 72 hours, it is not a case where we have seen in some of the countries for you to lodge an application within the 72 hours, but rather an order must be granted within that 72 hours. So it is not a case for just the lodging of the application, and then defendant comes to the court and says, the defense comes to the court, and says, okay, well, we would like an adjournment because we would like more time, etc., etc. No, the court must ensure, even if it were to consider giving more time prior to the formal or the hearing of the initial detention, it must give an order to the applicant within that 72-hour period. Anything outside of that would be considered invalid and will attract the return of the funds to the respondent. Next slide. So when we are talking about, you know, the initial period, we have to look at that 72-hour period, and we have to make sure that we are sticking within the ambits of that 72-hour period. Next slide. So this is a very good example that we try to formulate in terms of time in relation to how time will count in a circumstance like your legislation where you have Saturday or you have public holidays that are excluded. So if you have a seizure on Thursday at 6 a.m. and normally what we will say is that it will count from Thursday 6 a.m. to Friday 6 a.m. would be one day, which is 24 hours, right? So from the point of seizure Thursday at 6 a.m., that would be 22. Friday, it would be 24 hours. So when we look at the end of Friday, we now have to say from 6:01 a.m. Friday morning, right, to Monday 6 a.m. That is another 24 hours, right? But we had to exclude Saturday and Sunday, right? We had to exclude Saturday and Sunday. So it means between Thursday and the end of Friday, 36 hours would have expired. And then we stop counting Saturday and Sunday, and we go over to Monday. And at the end of Monday, we had 60 hours expiring. It means, therefore, that the applicant has until Tuesday morning at 6 a.m. in order to bring an application or before the court to obtain an order. Now, in these particular circumstances where the application is, the time is going to expire on Tuesday morning at 6 a.m., the wisest thing would be for the application to be made on the Monday because we know that the courts do not open at 6 a.m., right? So next slide. This would be the end of our presentation, but I think the focus of the this particular initial phase of the cash summary proceedings is really to look at, you know, what are those salient principles and those what I consider standard best practices that would ensure that we are following and falling within the ambits and the parameters of the legislation. Thank you very much for your time, and thank you very much for your attention. We are open to any questions that you might have.
Right, so we'd like to thank Mr. Sutherland and Mr. Alexander and of course the team at the Regional Security System in Barbados. So we'll open the floor to questions just as we're about to pause for our lunch break. So the floor is open to the judges and magistrates.
No questions from me.
I take it as it's that the presentation was very thorough, and that's why there are no questions.
Yes, we will provide the slides because I know that maybe some of the cases will be useful for application. So we will provide the slides, and we thank you very much again, Chief Justices and the Supreme Court for the for the invitation. And we look forward to continue working and collaborating with you on these areas as we seek to arrest crime in every way possible through the utilization of asset recovery tools.
Okay, so thank you very, very much. And we'll of course thank you more formally at the vote of thanks this afternoon. So just
Yes,
as
we thank you.
Just as we pause, I'd like to acknowledge that Mrs. Suzanne Watson-Bonner is in the meeting. So we're about to take a break, a short break until 12:15, where we will return for the second half of today's presentation. So thank you very much, everyone. Right, so good afternoon, Honorable Chief Justice, Honorable Judges, Honorable Magistrates. I'd like to formally welcome everybody back to this afternoon's presentation. We continue our work on the proceeds of crime, and we'd like to welcome Ms. Susan Watson-Bonner, who's joining us from Jamaica. So I hand this over to Ms. Watson-Bonner for this informative presentation. Thank you.
Good afternoon again, and thank you so very much for the welcome, Mr. Emmanuel. So I start off with a quote from Justice Sykes, Chief Justice of Jamaica, who says that the underlying assumption of poker is that the Crown has the right, duty, and obligation to undermine the capacity of criminals to continue their criminal lifestyle by weakening their economic viability. And you may wonder why I start there. I start there because when Jamaica implemented the Proceeds of Crimes Act in 2007, and the particular section that deals with recovery of property, whether it was through civil recovery or cash seizure, we found that many persons were opposed to the provisions. They thought that it breached constitutional rights and that it was depriving persons of property. The law, of course, in the European Union found that civil recovery, whether property or cash, was not in breach of any constitutional right, because constitutional rights were not geared at protecting criminal activities. And so the provisions as they were legal. And we've had many challenges in Jamaica in relation to the cash seizure provision, the cash forfeiture provisions. But at this stage, we are pretty clear, and there's a body of case law that has been developing regionally in relation to cash forfeiture. Jamaica, and I saw a recent case out of the Hippolyte et al. Case, which was mentioned earlier by my colleagues from the RSS. It's a case that basically touches and concerns every provision relative to cash seizure, cash forfeiture. And so it is quite interesting and enlightening to see the body of law that is being developed in relation to cash seizure. Might I please have my third slide? Fine. So the ordinance, the Proceeds of Crime ordinance out of the Turks and Caicos Island at section 110 speaks to cash forfeiture. Am I being heard?
Yes. Grenade launcher. I can't.
Okay, very well. Thank you very much. My slides are not moving. They were supposed to be controlled. I would now be at slide 3.
Yes, they're not moving. So can you give us 1 second to see if we can assist with that?
Very well, thank you. Can I please go back to slide 3? May I please have slide 3? Thank you.
I am on slide 3. I don't know.
I have, that's 4, the one above it, please.
Yes, we are seeing the 4th slide. If you forward the presentation to me in the chat, I can try to share it on my end as well.
Let me forward it to you. Manuel.
All right, let me, Mr. Joseph, would you prefer if I forward it? Does it matter?
Go ahead, forward it to him.
Okay, very well. I'm sorry, I crave your indulgence a moment, please, for the technical challenges.
Thank you very much. No problem at all.
It sent, Mr. Emmanuel.
Okay, thank you.
You're welcome. Have you received it, Mr. Emmanuel?
Yes, I have received it. I'm just opening it now. So thank you very
Okay,
much.
very well, just checking.
So can I confirm that you can see these slides?
I'm seeing.
Yes.
Sure. Very well. Let me start again. Sorry for the delay. All right, so I
Thank you very
start
much.
with the first slide, a quote from Justice Sykes in one of our asset recovery cases. And it says that the underlying assumption of the POCA, which is the Proceeds of Crimes Act in Jamaica, yours is the Proceeds of Crime Ordinance, is that the Crown has the right duty and obligation to undermine the capacity of criminals to continue their criminal lifestyle by weakening their economic viability. And I go back to say that at the time the Proceeds of Crimes Act was promulgated in Jamaica, there was hesitancy on the part of many persons to implement the provisions or to treat it in a particular way because it felt like the law was so draconian and actually served to deprive people of their property. The thing is that we live in a society, and regionally it happens, where we have persons who are hustlers, and not hustlers in a bad sense, but they are persons who make do. And so with very little means, we do all the things that is necessary to support our family, and oftentimes we do not have. So we have a large unbanked sector in our society, persons who are not committed to going through the rigors of entering the formal banking process and to be financially included in a particular way. And so sometimes, and we're a large cash-based society too. And so from time to time, we find persons with large volumes of cash, Jamaica being no different. But then again, when you look at what it costs to live in Jamaica and the cost of things, then it's not unnatural for persons to have large amounts of cash. And so we balance that though with the increase that we see in crime. And a part of the reason for the increase that we see in crime is because it has been funded by money. And so in striking that balance between what someone may have legitimately, but does not have engagement in the formal sector, the informal economy not being tantamount to the illicit or the illegal economy. And so you have to balance that with persons who are engaged in criminal activities, with persons who just don't have the formal backing, but still has legitimate monies. Right, so the Section 110 of the Proceeds of Crime Ordinance sets out that cash forfeiture orders relative to cash seizures can be made in the absence of criminal conviction or criminal proceedings. And so, as stated by my colleagues earlier from the RSS, the cash forfeiture application is made irrespective of whether or not the person from whom the cash was seized has been convicted for any criminal offense, whether or not there was in fact criminal charges, but those criminal charges did not result in the conviction of the party, and there need not be any criminal proceedings at all that was initiated. It does not impact the application for the forfeiture of the cash that was seized. And what's a good part of the cash forfeiture application? At the time when the cash forfeiture application is made, the magistrate is looking only at the application for forfeiture. What transpired before? It's not before the magistrate. Number one, we're not sitting in any review of the orders that have been granted by your sister or brother or your colleague of equivalent jurisdiction prior to the matter coming before you for forfeiture. And any questions arising from the seizure of the cash leading up to the point prior to which the application for forfeiture is made would be the subject of an appeal, and your law states that appeals are to the Supreme Court. And so that is a place where any questions in relation to the validity of the seizure, the validity of the search that caused the seizure to take place would have gone on appeal to your Supreme Court. So when it comes to the forfeiture hearing, the matter before you is whether or not the cash is recoverable property or was intended for use by anyone in unlawful conduct. May I have the next slide, please? Thank you. Section 110.1 says that while cash is detained under Section 107, an application for forfeiture of the whole or any part may be made to the magistrate court by a police officer. I'm curious because the law does state that seizure may take place by a police officer or a customs officer. While we're not going back and we're at the point of forfeiture, and we'll take me to mean that everything has been done up to now is consistent and application for forfeiture is being made. I wondered when my colleagues were presenting before, how do we transition where the cash is seized by a custom officer? How do we transition to the police officer to ensure that the suspicion, the requisite suspicion to the seizure and all of that takes place? But I'm sure you would have addressed that in the previous presentation, or have addressed your mind to it when conducting such a procedure, if you are concerned in the seizure of the application for seizure and for continued detention. Section 1110, subsection 2, on an application under subsection 1, the magistrate court may order the forfeiture of the cash or any part of it if satisfied that the cash or any part of it is recoverable property or intended by any person for use in unlawful conduct. And what is important is that these two limbs are not conjunctive. So it's either the property is recoverable property or it is intended for use by anyone in unlawful conduct. And your sections 60 and 61 speaks to recoverable property, unlawful conduct, and 62 speaks to recoverable property. And so you are clear as to what those standards are and what it is that the officer who is seeking to have the cash forfeited, what is it that he needs to come to you to cause you to believe on a balance of probabilities that the cash is either recoverable property or is intended by anyone for use in unlawful conduct. Next slide, please. Thank you. Section 110, subsection 4, speaks to how you treat with cash once an application for forfeiture has been made. And it is, in effect, it stops the clock from running. In the previous presentation, the issue of time is critical. When the cash is retained, how soon after it is, your law speaks about 48 hours, and it's not 4 days, it's not 2 days, it's 48 hours. And so time is critical, time is of the essence, and therefore it is very strict as to how those timelines are met, and basically incurable if it is that those timelines are not met. When you get to the application for forfeiture, though, it says that once the application for forfeiture is filed, then it may not, the cash detained may not be released under any power conferred by this part until any proceedings pursuant to the application, including any proceedings on appeal, are concluded. And so what you've seen for us particularly, and I use a Jamaican example, since we have been doing cash seizures and cash forfeiture since 2007, is that once the officer recognizes in some instances that a magistrate is unlikely to grant any further order for continued detention, the officer files an application for forfeiture, which stops time from running and uses some of that time to conclude this investigation to put before the magistrate, because you are allowed to file further affidavits in support of the application up to the time that the hearing takes place. Next slide, please. Thank you. Appeal against forfeiture. So where the court orders forfeiture, the parties allowed from whom the cash was seized is allowed to make applications for appeal. The appeal must be done within 30 days of the date on which the order was made by the magistrate. And appeals against orders for forfeiture are made to the Supreme Court. What is interesting for the TCI is that your appeals go to the Supreme Court. And if your Supreme Court is like ours in Jamaica, then it is a court of inherent jurisdiction. And what I've noticed is that your section 111 subsection 3 allows for a re-hearing by the court, which means that, or I take that to mean that the application is being reheard. When our appeal in Jamaica goes to the Court of Appeal, the Court of Appeal in Jamaica is not a court of inherent jurisdiction. And so it only hears the matters that are before it. And so the distinction here, quite interesting. And I can't imagine the amount of resources that would go into having a rehearing of a matter that was heard in the lower court and then gone up to the Supreme Court for an appeal in these circumstances. But it might be to the benefit of the persons from whom the cash was seized, and they're having their matter heard twice. Section 111.4, if the Supreme Court upholds the appeal, it may order the release of the cash. And so in those circumstances, if the court finds in favor of the decision of the magistrate, I'm sorry, Judge Byer, would you like to make that comment?
Sorry, I'm sorry to interrupt your presentation, but just to, when you are making that statement, that to make sure that it is understood that it is only the person against whom the order is made. So other jurisdictions allow for, if the Crown or the state authority is not satisfied that the order was not made, they can appeal. But it doesn't happen in the TCI. That's not provided for in their legislation.
Okay, very well. So you're saying that appeal is only applicable to the person from whom the cash has been forfeited?
Yes, yes.
Okay, fine. I'm sorry, you know, I looked at the provisions and appeal. Let me just quickly, I crave your indulgence a moment. When I look at section 1111, it says any party in proceedings for which a forfeiture order is made. And I took any party to mean that any party in the strictest language of the law, but I'm guided. And so I took any party to mean that it could be either the officer who is applying for the forfeiture or the person from whom the cash was seized. And so I am guided. I'm guided. Thank you.
Right. Okay.
Thank you, Justice Byer, and welcome.
Thank you very much. Sorry for being late to the presentation.
Not at
May I
all.
have the next slide, please? Thank you. And if the order for forfeiture is granted, the forfeited cash and any interest accrued thereon is paid into the fund. And this arose from an amendment to the ordinance in 2010. Next slide, please. Thank you. From time to time, cash is seized, and the person from whom the cash is seized indicates that the cash is not theirs, or we might find that cash is seized, and during the course of the investigation, you can actually, the officer is actually able to determine the victims from whom the cash has been obtained and the person who has suffered loss as a result. We use the example of the lottery scamming because it's very prevalent in Jamaica. And so wherever you have acquisitive crime, which in these circumstances, you may have an acquisitive crime, particular where it is money is obtained through unlawful conduct. It might not be unlawful conduct on the where the person actually engaged, probably like in drug trafficking or something, but unlawful conduct on the basis that they might have deprived someone of cash. And in these circumstances, victim and owners are allowed within a particular time and within the provisions of law set out at section 113 to make application for the return of those sums to them. So the law does consider and restitution where persons have suffered loss. Next slide, please. Thank you. And section 113 sets out the process by which victims and owners may seek to recover cash for which they have been deprived. Compensation. Again, your compensation provisions vary from Jamaica's. Jamaica's compensation provision is very specific, that it is to be lodged. I mean, similar to yours, the similarities are that it should be lodged in an interest-bearing account as soon as is reasonably practicable. For us, it's within 72 hours. For you, it's within 48 hours. And save and except in circumstances where the cash is being held for evidential purposes. In circumstances where the cash is not deposited in an interest-bearing account as soon as is reasonably practicable, then as magistrates, you would have a discretion to make an order for the person to get interest. It gives you the discretion to make payments for interest where it will have been earned in the period in question if it had been held in an interest-bearing account. And I'm thinking that it now requires the magistrate to be familiar with what those interest amounts are and what would be the interest that would be earned. That requires a calculation of what the interest would have been if it had been placed in an interest-bearing account at the time that it ought to have been placed in an interest-bearing account. My questions would have to be asked as to how do you determine which, may I please have the next slide? Which of the, how do I invest my money? Where, if I want to put it in the most lucrative, but at the same time, the most risky account that I might get interest on, if I'm a risk taker. How is it that a magistrate determines which interest to apply when you have circumstances where the interest vary? Do we do an aggregate and give an amount? But the discretion is there, and it will be interesting to see how it is treated within those circumstances when you do have to make a decision on how to make an order in relation to compensation on the basis that the cash was not deposited within a particular time or deposited at all. The law at section 114, subsection 4 goes on to say that even if the magistrate's court is satisfied that taking account of an interest to be paid under section 108 of any amount paid under subsection 2, the applicant has suffered loss as a result of the detention of the cash and that the circumstances are exceptional, the magistrate court may order compensation or additional compensation to be paid to him. Now, because your law is developing, then it would be interesting for court to determine what are those exceptional circumstances and how would you then arrive at additional compensation. Our law does not speak about exceptional circumstances, and so it would be good for some courts to make a decision as to what is exceptional. I don't know if you go to contract law and determine what someone could earn and everything, but I give you an example. In 2010, when Jamaica had the excursion, the Tivolian excursion, incursion, when we had a state of emergency in relation to the extradition of an individual who is still serving time in the US. Cash had been seized from someone who operates and engages in a lot of road construction with the government of Jamaica. But that person was also a business partner to Christopher Dudusco, who was being extradited to the US and who was the cause of the incursion taking place. The cash seizure took place and all right, the cash seizure was for the amount of $3 million. Suffice it to say, by the time the attorney came to court, they said that it was $5 million and that when he locked his safe the evening prior to the incursion taking place, it was $5 million. That aside, though, an application because the incursion was going on, financial institutions were locked and the cash had not been deposited in an interest-bearing account for a while. The case was riddled with challenges that I will not get into, but because I'm speaking particularly about the point of compensation. Suffice it to say, at the end, the cash was not ordered forfeited on the basis that the documents that were uplifted at the time of the seizure, the person from whom the cash was seized indicated that if he were to get those documents, he would have been able to show how he got the cash and the amount of cash that he had. The police were not able to provide the documentation. They even went to the Court of Appeal in relation to that issue. Undertakings were given for the documents to be handed over to counsel, and it was not done. So we were duty bound in those circumstances to offer no further evidence because the Crown was deemed to have not placed the person from whom the cash was seized in a position to respond to the application for forfeiture. It doesn't place as a reverse burden. The law does not place as a reverse burden on the person from whom the cash was seized, but it behoves the person from whom the cash was seized to say something in response to the Crown application for forfeiture. Because without saying something, then the court can take that to mean that, look, you have no interest in this cash, it is not your money, and it's coming from some illegitimate source. That is why we can't speak to. Get back to the point of compensation. He indicated and filed an application for compensation. Remember, I said that we had a cash seizure form which said that $3 million was seized. Well, he filed an application for cash seizure to the tune of 346 million Jamaican dollars, indicating that he operated a hardware and that if he had the $3 million, he would have bought and resold cement and other building materials. And over the period of time between the seizure and the application, he would have made 346 million Jamaican dollars with the investment of $3 million. Well, our provision for compensation speaks about compensation being given at the treasury bill rate of interest. Now, at the time, the treasury bill rate of interest in Jamaica was about 7%. It's about 5 or 6 now. But our response to the application was that compensation is not at large. And therefore, it can't be that someone is going to come with figures that are arbitrary and to say that they can. Number one is audited financial statements were not audited. And so when he called his auditor accountant to speak to them, it came out in evidence on cross-examination that he could not verify because there were certain things that he requested that had not been provided to them. So while he was able to do accounts with what he had gotten, there was still information, and so that is why they were not verified. And the court agreed with us that compensation cannot be at large in those circumstances. Now, your legislation is different, and so again, it would be interesting to see how these provisions for compensation are treated. And how does the court determine reasonableness having regard to the loss suffered and any other relevant circumstances? What are those circumstances that you're supposed to look at? And what's reasonableness? What's the objective nature of the reasonableness that you're to be making to determine all of that? The next point I'd like to make, though, in relation to compensation is that there's a case relative to cost, though, that speaks about cost does not always follow the successful party. And I'm thinking that it's the Hickman case where police officers and the circumstances, authorized officers are to be allowed to do their work and to do their work freely without having over their heads without that extraneous cost. And this case, compensation is going to be ordered against the state because, and so cause them to be hesitant in how they do their work. And so I guess with all of that, I don't know how you balance that, but the law is clear. And so as creatures of statutes, and you would have to comply with it. But all of those things are going to have to be taken into consideration when you're making a decision or considering an application for compensation, I believe. Next slide, please. Thank you. Does it have to, in relation to cash, the limit and the minimum, and your law speaks to the application for forfeiture, whether it's recoverable property or intended for use in unlawful conduct, and it needs a minimum amount. The minimum amount of $250 seems small relative to Jamaica, but if that is a sufficient amount in the TCR, or it is what the law says, so you have to work with it. But does it all have to be seized from one person? No. We have to look at the issue of connectedness, interconnectedness. And if you can find that persons are traveling together, but want to cause it to appear as though they are apart, but when the circumstances show that they're acting together and that they might be in possession of recoverable property or property that is intended for use in unlawful conduct, and the nexus is sufficient, even if one person, an individual, does not have the minimum amount, but collectively they have the minimum amount, the case of the officer says that it can be seized. And it might be one individual, it may be more than one individual. And it may not be an individual, it may be an unattended parcel, or perhaps I've noticed that your statute again speaks to individuals not needing to subject themselves to an intimate search. What does intimate mean in terms of the law? Because if I have seized cash and I know that an officer has valid reasons, legal reasons to be on premises, I could just put the cash somewhere where I think I don't have to subject myself to that intimate search. What happens in that circumstance? In those circumstances, does the officer take me with him and then cause that search to be done? Is it, or how do we look at it? Does it mean that the cash has to be in a place where the officer can find it? We have to look at the provisions in a way where they do not operate to cause unimplementable operation of the sections. And so all of that has to be given consideration too, because, you know, criminals find every single way to circumvent the law, and these provisions are promulgated with, and in operating as magistrates, one of the things that is required and has to operate on your minds at all times is the mischief that the provisions are seeking to cure, and how criminals will seek to circumvent the law in order to achieve the benefit. And while not operating outside of the law, it is incumbent on all of you to ensure that they are deprived of cash that is either intended for use in unlawful conduct or are recovered property. Next slide, please. Thank you. Cash forfeiture. So back to the evidence that shows if the cash is not in its entirety on one person meeting the minimum amount, but it can be aggregated, then you can seize it. Where it cannot be, then it means that it doesn't meet the requisite minimum amount of 250 in the circumstances, and then it requires us to look at the reality and to see whether or not this is a concerted effort to cause us to believe that these persons are not operating together, but it has to be taken on a case-by-case basis, right? And work together, a common source or has a common destination. How do we arrive at that conclusion to determine that it is a single operation, though several persons are involved? Can you go back one slide, please? All right, fine. Next one. Yes. And I had mentioned this earlier before that the cash forfeiture proceedings can be invoked whether or not criminal proceedings have been brought for a criminal offense in connection with the property, or whether or not the defendant has been acquitted of an offense connected with the property. And so, as would have been stated earlier in the earlier presentation, the reason for this is that the action being brought for the recovery or the forfeiture of the cash is against the cash. It's an application in rem, and so you look at the circumstances surrounding the cash, particularly more than the person, and so there need not be any criminal. The person need not be convicted, or that there were any criminal proceedings in relation to the cash that we're seeking to forfeit. And we spoke about the definition for unlawful conduct already, and the big part of this is that as magistrates, when considering the application for forfeiture, decision is to be made on a balance of probabilities, not at the very high standard of beyond reasonable doubt. It's on a balance of probabilities. Is it more likely than not that the cash that is the subject of the application for forfeiture was intended for use in unlawful conduct or constitute recoverable property? A person's benefit from recoverable property, a person's benefit from unlawful conduct. Next. And again, this slide is just repeating what I just discussed before. The court must decide on a balance of probability whether the cash was obtained through unlawful conduct or is intended for use in unlawful conduct, and whether or not it is recoverable property. The balance of probability is more likely than not. Only a 51% chance of success is needed. Meaning of unlawful conduct. I will not go into reading out and saying, I'm sure everyone here knows what it is. It is just there for information purposes. The meaning of unlawful conduct is set out in section 60, subsection 1 and subsections 1 and 2. Next slide, please. Thank you. Meaning of property obtained through unlawful conduct. And again, it is information that you all know, and so we can skip over this slide to cash forfeitures. Cash forfeiture. The authorities concerning cash forfeiture proceedings have clearly established that in these proceedings, it's not necessary to identify or prove any criminal conduct. So in making the application for forfeiture, the police officer need not to, it is different from an information laying a charge for someone who's going to be charged and subjected before the criminal court for and is at pain of prosecution. These are civil proceedings, and so while it can be arbitrary, you just see somebody or you're on premises and you just seize it, and without more, oh, this person shouldn't have this amount of cash. This person doesn't look like someone who could have that. This person doesn't work. Fine, I don't work, but I have a source. Whether that's my parents or whether it's my gentleman, or whether I'm lucky, so I gamble, and when I gamble, I win. I'm in the habit of winning, right? So you need not prove any particular criminal conduct, but there must be some general idea of what it is that this person is engaging in, or is it that we can say the source of the cash for you to determine whether or not it was intended for use in unlawful conduct or constitutes recovery of the property. So the officer is not required to say to you, on the 10th day of May, Suzanne Watson Warner engaged in criminal conduct with drug trafficking, resulting in her having $3,500 which is the benefit of the conduct which she engaged in on the 10th of May. No, the law is not asking you for that, but at the same time, it can't seem that we just bad-minded, and because the person, I think, she is supposed to, or he's supposed to have this amount of money, then we go and say, all right, we're going to apply for forfeiture, and without more, it is okay for us to do that. Instead of proving criminal conduct, what is important is the circumstances under which the cash was found and the explanation given by the defendant or any other individual, which may lead to an inference on the balance of probabilities that the cash was unlawfully obtained or was intended for an unlawful purpose. Supports the points that I've just made, that the circumstances when taken as a whole is what is going to cause you as magistrates to make a determination as to whether or not it would have caused the officer who have seized the cash to make that ultimate step to make an application for a forfeiture. And it is that evidence which he presents to you is going to cause you to make your order for a forfeiture. If you seize cash without more, then you'll be making an application for the release of the cash and the interest that has accrued on it. Thank you. Next slide, please. Thank you. Factors a tribunal of law and fact may take into consideration. And some of those circumstances include the fact that there was an attempt to conceal money, where the money was hidden in several pockets of jeans within the respondent's suitcase or behind the refrigerator. The fact that the respondent is party to an attempt to conceal the money. Differences in accounts given by the respondent and any third party, the purpose or intended use of the cash, where the respondent claims some of the money to be his, while a third party claims the money belongs to him. The fact that the explanation given by the respondent or any third party as to the source or intended use of the cash was found to be untrue. And these circumstances all come from cases that have come up in Jamaica. In the very first case, I have the name problem on the other slides, but this is the cash was in jeans pocket, several jeans pocket. Now, if it is that you go overseas and you work so hard for your money, it is unlikely, highly unlikely, that you're going to be divvying up your money and put it in pockets of clothes, in your clothes, and putting it on a suitcase which you don't have sight of, and sending it on any plane to come anywhere. You're going to hold that in your handbag and you're going to hold it tight under your arm if you don't already use the banking system. The next thing is that the attempt. And so lots of persons have false compartments in different suitcases, different parts of their bags. They're hiding the money, the lining of their bags and everything. And as magistrates, you would know. And there is case law which tells you that persons don't always, when persons lie, it is not always indicative of guilt. because, you know, persons are afraid of police officers and have a fear or the moment of or the thought of being caught, you might answer in a way that probably is not true, but not always indicative. But again, the entire circumstances taken as a whole must lead to the natural inference that this person actions are indicative of someone who is trying to lie, to hide the true provenance of the cash, and to benefit from conduct which they would not want to reveal or they know is unlawful. Differences in accounts. So particularly where you have persons who claim that, okay, I'm carrying the cash that you have seized from me does not belong to me. It belongs, or some of it belongs to me, but some of it belongs to somebody else. And they've asked me to give it to a relative. But when if the person does come, then the person says something completely different from what that other person had said that the money was for. Then again, those are all things that we are going to take into consideration. Next slide, please. Thank you. So an example of a case out of Jamaica is Sandra Marie Cavalier. And she had hidden the money in several jeans pants. She had jeans in her suitcase and she had hidden the money all over them. She knew that money was in her suitcase and was a party to concealing the money. She gave an explanation for the cash that was completely different from what the third party had said. And the explanation of the court found that the lies were sufficient in the circumstances for the magistrate to have found that the cash was either from recoverable property or intended for use in unlawful conduct. And so the Court of Appeal upheld the order made by the magistrate for the forfeiture of the seized cash in these circumstances. This case is a case of a gentleman who was traveling from the UK, and he told the officers that he had $8,000 US. The custom officer when he was stopped in the airport. The custom officer obviously did not believe him because of how he was acting at the time. And when she told him to come with her while they were walking to an area for her to have another one of her colleagues participate in the search, he said to her, I have a little more than $8,000 and I will give you something not to search. That already is a big red flag. They found that he had 14,000 pounds. They looked at the fact that he was a security guard, that he had made several trips to the UK, which was inconsistent with any earnings that he would have had being a security guard. And we are all aware of the cost to travel to the UK. He had indicated that he was carrying the money to build a house, but he never presented any plans or anything for the building, nothing to show that money, and he could not show where the money was coming from. Secondly, is where the money were being in the groin area of his pants when he was searched. And so again, this would reveal the need for an internet search. And there were conflicting information given about the source of how he had come by the cash. And so all of those things taken, the bribe, the place where the cash was found, the conflicting explanations, again, the court that ordered that the circumstances when taken as a whole was sufficient for the order for forfeiture to have been made. And so the decision of the lower court, the magistrate's court, was upheld in the Court of Appeal also. Winston Pusey, Miss Maha Byer was working for Mr. Pusey, And she was a bartender and indicated that she was going overseas to buy car parts from Mr. Pusey. She said that she was going overseas to buy clothes to come back to sell, that a portion of the money was hers and a portion was for Mr. Pusey. Again, the different stories that they provided to the police, and she said a particular portion of the 12,000 belonged to her. When Mr. Pusey came, he gave a larger portion that belonged to him to buy car parts. And so all of those things were taken into consideration. Additionally, what was taken into consideration was the fact that Mr. Pusey, on a previous occasion, Mrs. Mahabir Barrett was going to Panama, and Panama is a transshipment point for drug-related activities. And Mr. Pusey had on a previous occasion been convicted or arrested for drug activities. And so that past conduct is something that can be relied on in cash forfeiture cases. And prior to the previous presentation, the case of Alien Best would have been mentioned in relation to the reliance on past conduct, because where it can be shown that a party has a propensity of operating in a particular way, then the court has found that in civil proceedings, there is no barrier to relying on past criminal conduct. There is also a case in Jamaica which speaks to the reliance in these proceedings on past conduct, which says that the probative value of the information outweighs the prejudicial effect, then it is okay to rely on the material. I will give you the name of the case. I have it, but the name of the case is just eluding me right now. But I have it close by, and so I can give you the name of that case. And so, just to repeat, the reliance on past criminal activities of an individual can be used in these proceedings. We look at circumstances when we're doing these cases, because you might not have a clear criminal conduct, because where you have persons engaged in drug activity, or you find money close to drugs, you find a person with money and drugs, or you find a person who there's a clear criminal connection, then the application for forfeiture would be much easier, would be much easier in the circumstances to prove on the part of the applicant for the application for forfeiture. And so outside of a clear one-on-one where you can just see where the conduct is or the intent for the use of the funds is, then you look at the entire circumstances of the case and making a decision as to whether or not you should grant an application for forfeiture. May I have the next slide, please? Thank you.
Right.
Right. And so we mentioned the case of Sandra Marie Cavalier, where again the matter had gone in appeal. Winston Pusey, he had a previous conviction. Leroy Smith, he was the one who tried to bribe the customs officer, in addition to the money was in his groin area, and the fact that he was a security guard and made several trips to and from the UK was not commensurate with his ordinary course of life or living, and he did not provide any substantial or any evidence capable of meeting a standard that could even consider that the monies had come from legitimate source. And so we have the case of Anwar again, which speaks to how is it that you may make a determination, among other things, what are those circumstances that might amount to or cause you to make an application for forfeiture. And I have set out a number of other cases that we could provide to guide you in your application for forfeiture as you go forward to implement in your jurisdiction forfeiture of seized cash.
So, thank you, Ms. Watson-Bonner. So I think we're scheduled to take a break now. So if we can pause until 1:30, and then we can resume the second half of the presentation.
Okay, very well. I will. Thank you.
So thank you very much.
Mr. Emmanuel?
Hi, good afternoon, Justice Byer.
Good afternoon, sir. Just want to double check, so we're gonna still be on to start at 2:10.
Yes, we'll try to keep that as very close to 2:10 as possible, yes.
And you would be assisting me with my PowerPoint.
Yes, no problem at all.
Okay, thank you.
Thank you. Good afternoon, Ms. Watson-Bonner. Are you ready to resume?
Hi, good afternoon again, and I'm so sorry to be late. I was chatting away because I was looking at my provision under section 80 of my legislation, which deals with appeals, and comparing it to yours. And based on the guidance and commitment and comment made by Justice Byer earlier, and I realized that my I really was in fact thinking of my provisions when I made that comment this morning, and not your provision, which is somewhat narrower than the section 80 of the Jamaican Proceeds of Crime Act, where your provision speaks to the appeal. Any party to proceedings in which a forfeiture order is made who is aggrieved by the order may appeal to the Supreme Court. Now, and I make the point just to clear up the uncertainty that I had shown this morning, is that in our legislation in Jamaica, you can appeal against the order or is aggrieved by the decision of the court in relation to thereto. So therefore, you might not be appealing the actual order for forfeiture, but if the court in the circumstances in Jamaica were to make an order in relation to the payment of interest or the payment of compensation, the state probably would still want to appeal if we do not think that those orders ought to have been granted. So our provision in these circumstances is a little bit wider than yours. So let me get back on track, since time is of the essence, and just to say that do we go with the case of the cash or cashless society? It's not that the provisions are saying that persons are supposed to go without cash. But when we look at the court in the director of the Asset Recovery Agency and others, David Green, the court said that the decisions are more than a reflection of the fact that in today's cashless society, the ordinary law-abiding citizen does not normally have any need to keep large numbers of banknotes in his possession. It would always be safer, bearing in mind the risk of loss through accident or crime, more profitable, bearing in mind the opportunity to earn interest, and more convenient, bearing in mind the many ways of paying for lawful goods and services, not to be in possession of a large sum of money in the form of banknotes. Just as the law-abiding citizen normally has no need to keep large amounts of banknotes in his possession, so the criminal will find property that in particular form convenient as an untraceable means of funding crime. The four decisions do no more than recognize that conduct consisting in the mere fact of having a very large sum of cash in the forms of banknotes in one possession, in certain circumstances, the example of an airport, may well provide reasonable grounds for suspicion and demand an answer. And so this case speaks to, and I mean, we've had cases in Jamaica that speaks to persons' familiarity with the banking, with banking, and have engaged in banking. One of the very largest civil recovery matters that we have had in Jamaica, the case of the frozen cash, and that was when cash in the amount of $350,000 was found packaged like meat in a refrigerator in Jamaica in 2007. That was not a cash seizure. We had initially filed an application for cash seizure, but before the order for continued detention had expired, we had filed an application in the Supreme Court for civil recovery, and had brought the cash under the purview of the Supreme Court, because there were other properties that were owned by the parties, and so we wanted to keep all the property together and not to have the cash dealt with in a separate jurisdiction. But I say that to say that the court looked at, and one of the things that the court looked at in that and came out in the judgment in the Loris Miller case was that they were no strangers to the banking sector because they had several accounts at financial institutions. And again, it is similar to persons traveling the airport. We have bank-to-bank transfers. What I find now is that I've had relatives who are coming, and what they do is that they send money to themselves to Western Union, and then when they come, they go to Western Union and take the monies that they would have to spend when they get to Jamaica. And so these are things that you would have to look at. Why would someone choose to be traveling with? And in the case of Leroy Smith, one of the things that he had told them why he had not declared the money was that he was afraid that if he declared the money, he would be held up and robbed because of the belief that when he declared the information, somehow a member of staff at the airport would disclose that to some person outside, and they would hold him up when he exited the airport, and the monies would be stolen. And so these are, but the safest way to do that then is to send it through some formal sector where you are not carrying this money on your person and run the risk of it being stolen for real. And so those are some of the things that will come before you and you will have to look at. And again, I end by saying it is sometimes it's not very clear, but it requires more than the person does not have the income to be in possession of this sum of money. But by the time it gets to you and the application for forfeiture, the officer should have sufficient to cause you on a balance of probabilities to make a decision as to whether or not cash is in fact recoverable property or was intended for use by anyone in unlawful conduct. Next slide, please. Thank you so very much for giving me the opportunity and the pleasure of doing this presentation. I hope that you would have derived some benefit, and I am open to any questions that you may have. Thank you very much again.
Thank you very much, Ms. Watson-Bonner, for that very informative presentation. So now I'll open the floor to questions from our honorable judges and magistrates.
You're welcome, Mr. Nicola. And thank you too.
I just had one question, and is, have you seen cases where attorneys have been subject to these types of orders, where say you are defending or representing or known to be representing like a drug deal or something? Would that come into play if you are found with cash and you say that's fees that you've received?
No, we've not had that case, but Jamaica does not. All right, when the example that I used earlier, the case of Christopher Dudosco, in the US, when he was convicted or when he was appearing in court in the US, when he had been extradited and reached the US, one of the things that he had to do, or he had to prove that the sums that he was using to pay attorneys had come from a legitimate source. No, we don't have any such requirement in Jamaica. And no attorney, we have a matter in Jamaica now that is before the court where an attorney has been charged with money laundering. That is the case of Andrew Hamilton, who was a convicted drug dealer from the US. He was extradited, and there's a recovery order to the extent of about $100 million in terms of property that he has. The attorney was charged for money laundering on the basis that a substantial amount of the property that he would have purchased in cases where the attorney would have indicated that he signed while he was on a visit to Jamaica, signed the transfer documents or documents to purchase those properties. Evidence was provided to the court to show that he could not and was not in Jamaica at the time. As a matter of fact, there is one occasion when he was actually incarcerated in the state at the time, when the document indicated that he was in Jamaica or signed the document while on a visit to Jamaica. And from all appearance, he had a continuous retainer with that attorney. I mean, they say each transaction is a separate retainer, but he had that attorney substantially acted for him in every single transaction. And you're talking about someone who, over a period of time, would have owned over 20 odd different properties, and these were substantial properties. So that's the only case we have had. But specifically to your question, no, we've not required any attorney to prove that the sums that they're getting from clients for fees are not covered with property or in property that was intended for use in unlawful funds.
Okay, thank you very much.
You're welcome.
So if there are no further questions, I'd like to thank you, Mrs. Watson-Bonner, for a very informative presentation. And we'd ask you to stay around for the vote of thanks, the formal vote of thanks at the closing.
Very well. Thank you too. And thanks to your audience.
Thank you. I'd now like to ask Justice Byer, is it okay if you present now?
Yes, that's fine. I am ready to do so.
Okay, thank you very much. So let me formally introduce Justice Byer, who's joining us from the Eastern Caribbean Supreme Court, to also present today on the proceeds of crime. So thank you, Justice Byer.
I'm going to see if I can organize this PowerPoint for myself. So I have it. I'm hoping you can see the screen as well. I've shared my screen.
Yes, we can.
Okay. So good afternoon, and thank you so much for inviting me to make this presentation to the learned judges and magistrates of the Turks and Caicos, and good afternoon, Madam Chief Justice as well. Thank you for this opportunity. I haven't been on all day, but having looked at the program, I need to say this up front. You're going to possibly see a lot of overlap between what I'm going to be talking about in terms of further detention and what you may have heard, especially from Mrs. Watson-Bonner, in terms, I heard her when I came on in terms of timelines, etc. And the reason why I think that I need to start at that point, even though I'm going to be talking about further detention, is that you need to understand the context in which, as a judicial officer, you're going to be considering what do I take into consideration when this application is brought to me for further detention. So that being said, essentially, under your proceeds of crime ordinance, these are the sections that refer specifically to further detention. So even before there's even a consideration of forfeiture, the legislative regime, as you've heard, gives an interim stopgap provision whereby once cash is discovered in suspicious circumstances, and you heard Mrs. Watson Bonner talking about that, and I will even give an example when I had a matter that came up from appeal from the Magistrates Court in St. Vincent, where the money was in the Pringle chips can. And of course on their person as well. So under your section 106, as you've heard, a police officer is empowered to seize cash if he has reasonable grounds that it is either recoverable cash or part of the cash is recoverable cash and is not reasonably practical to seize only part. Now, when we go on, and that is section 106. And I want to just highlight something here. And again, because I was not on earlier, I'm not sure whether this was raised and whether you have taken it into consideration. But the period starts to run for your 72 hours. And I heard Mrs. Watson Bonner say that it's not days, it's hours. So when an application is brought to you, you need to ensure that it is in fact within the period when an order can be made for further detention. And it commences when the money is actually seized. So in your section 106(2), after seizures made by a police officer, under this section, the police, or in the case of a customs officer, the collector of customs shall promptly and in any event within 24 hours of the seizure, report that seizure to the Financial Crimes Unit. So that is when time starts to count. So if at any time, and I did raise this with the prosecutors when I was in Turks and Caicos a couple of weeks ago, and the officers who are on the front line, that is the police officers and the customs and immigration, that the clock starts ticking immediately. And as a judicial officer, you have to be aware that when you are looking at the application, that you are very familiar with and ensure that the evidence before you indicates when was the money seized. So that is that is under the section 106, in particularly 2, because the 24 hours is included in the 72 hours that they have to make the application for further detention. So then under section 107, any seizure of cash can be detained initially, as we have said, for a period of 72 hours. One, as I've just said again, one would therefore need to see that you need to adhere to the first period of 24 hours, as this period of initial seizure and notification must by necessity, how the legislation is drafted, be included in the initial 72 hours. Save and accept, of course, if it is on a Friday at 5 p.m., when you're looking at the evidence, you would not include the Saturday and the Sunday. And like with us here in Antigua this weekend, the Monday, which is a public holiday. So under 107.1, while a police officer who has seized cash under section 106.1 continues to have reasonable grounds for suspicion that cash seized under that section may be detained initially for a period of 72 hours. This is rarely any issue with the initial seizure, and once a police officer or other named law enforcement officer finds cash in suspicious circumstances, I just mentioned the Pringle can, the seizure is reasonable in all the circumstances. Where the investigative and sometimes more problematic issue would arise is what happens when the police are not ready to give up the money to the suspect or the interested person. He has not been charged. That individual upon who the cash is found on hasn't been charged with any offense. And there may in fact be probably no intention to charge him or her with an offense. But the fact of the existence of this large cash quantum on that individual is still suspicious. And section 1072 then provides for that bridge to consider what is happening with the cash. So under section 1072, as you see on the screen, there's provision to seek an order of the magistrate to extend the detention of the money for no more than 3 months from the date of the order, or if there is any further order for extension, no more than 2 years from the first order. So there are a couple of things I want to pause here and consider. When is the application to be made? At one point, initially, the debate was, is it that the 72 hours, that the application has to be made within 72 hours or after 72 hours? I think that is now settled law, that it is in fact has to be made before the 72 hours have expired. I have your two cases that you will see on the screen, and the one in particular that I want to speak to is the case of Walsh and Etherton against Commissioners of Customs and Excise. And you'll see the citation there. And I just want to read from paragraph 21 what the court said in relation to and what has to be considered by the judicial officer before whom the application is made for further detention. I have no doubt, and this was the court of, I believe it was the Queen's Bench Division, and there were several justices, Lord Justice Latham and Mr. Justice Forbes. I have no doubt that the wording of subsection 2, which is like the 1072, is such as to preclude any justice from making any order authorizing the continued detention of any cash under that section after the end of 48 hours from seizure. In the UK, the legislation provides for 48 hours. This statutory provision is one which, in my judgment, has to be construed strictly as explained by Scott, Baker J. and Kennedy L.J. in Henry. And I will refer to that case, Henry, as you can see up there as well on the screen. It is the R against Uxbridge Magistrates Court ex parte Henry. And I will also be speaking about that shortly. I acknowledge the consequence that there are practical difficulties which will confront customs and excise. And indeed, there may be some uncomfortable decisions that have to be made by justices under constraints of time as a result. But I can see no escape from the conclusion that the section only authorizes the detention of the property up to the end of 48 hours from seizure. The moment that 48 hours has elapsed, if there has been no extension, then there is no authority for the continued detention of that money. In other words, there is no existing authorization to retain the money which can be extended under section 42/section 107. The problem, it seems to me, arises from the fact that Parliament has decided that in this procedure, unlike in some others, the cut-off period should be as draconian as appears on its face. End of quote. So for me, essentially it means that regardless of how it may appear to you as a judicial officer that, yes, this money really should be detained further, there is investigations that should be done. If the state party and the individuals who are responsible for ensuring that the application is not brought to the court in a timely fashion, you have no choice but to dismiss it and make a determination as to how the money is to be returned to the individual. It's as simple as that. In the R against Uxbridge Magistrates Court, ex parte Henry, which I just referred to in the Walsh case, the court again reiterated this point about the fact that the timelines are not negotiable. Not negotiable. So in the ex parte Henry case, the case was dealing with provisions of the Drug Trafficking Act, similar to the Walsh, and where the period was for 48 hours. And the argument was made that the time period should be interpreted liberally, and the court said no. That any application for an extension must be done before the end of the period, because once the period has expired, there is no detention to extend. And further, since the provision creates a draconian effect on the property of others, it must be construed strictly. So from the judgment of Scott Baker J. in the ex parte Henry, he said, Parliament, in my judgment, has prescribed a specifically limited period, a period to be measured in hours. This is, as the learned editors of Archbold have pointed out, draconian legislation. In these circumstances, it is particularly important that its provisions should be strictly complied with. 48 hours is the period given to the Customs and Excise to make their further inquiries. And if they require more time than they have, to go to a magistrate to seek an appropriate order. It does not seem to me that that places any undue burden upon them. End of quote. So at the stage of seeking that further detention, it must be remembered that all you as the judicial officer has to prove at this stage, or to be satisfied of at this stage, is that there are reasonable grounds to suspect that the cash is recoverable cash and it is required to continue its detention. To one, make further inquiries into where the money came from, or whether any proceedings should be brought in relation to the monies for forfeiture proceedings. Or two, to allow proceedings that may have been started for an offense with which the cash is connected to be concluded. So as a judicial officer, all you have to be concerned with, and I tell you, is that when the investigating officer, the state agency, comes to you and says, we need to extend the detention, it is not for you at that point to go into the merits as to whether or not the further detention should occur. Now, I have said to obviously those individuals who are going to be responsible for those applications, that means that they need to provide you with sufficient information to make that determination. So if it is that they have sent inquiries of individuals or other state agencies, even outside of the borders of Turks and Caicos, seeking information on persons, the person upon whom the money has been found makes these statements, and they are now trying to investigate, and they have sent inquiries 3 weeks ago, still no response. All of that information needs to be before the judicial officer. The judicial officer cannot simply be a rubber stamp either to an application for further detention. They have to be satisfied that there are certain things that are in train in relation to that further investigation, which would require or would satisfy the need for such further detention. This approach has been called the light touch approach to construction of the statute, and is considered necessary as this consideration in terms of whether there should be further detention or not is at an early stage of the proceedings before even the formulation of charges. So The investigating officer, as I said, may not even, in fact, bring any charges against the individual who has the money. But the money is, as I said, suspicious. If investigations are done, and I will again give an example, I gave an example just a little while ago about where the money was found in the Pringles can in St. Vincent. And in that matter, it was, I believe, about $30,000 that may have been found in this Pringles can, bundled up tightly. The gentleman upon who the money was found had said, "Oh, please telling the the police who were doing like a search as he was leaving St. Vincent to go to one of the Grenadines Islands. Please don't open the Pringles. I have taken the Pringles to my daughter. You know, if you open the Pringles can, you're gonna make the Pringles stale, and you know, she's not gonna be able to eat it and enjoy it." The police hefting the Pringles can, this don't feel like chips. Opened it and then found the money. Of course, the story then changed, and you heard Mrs. Bonner speaking about how the stories then change, and those are things that will raise red flags, etc., etc. But that is when you then coming to court for forfeiture of the funds. At this stage, that kind of consideration is not, the depth of that inquiry by the court is not required. So I have another case on the screen. It was a consolidated appeal of Regina against the Chief Constable of Greater Manchester Police in City of Salford Magistrates Court, and Regina against Sarwar and Sons Knitwear Limited against Chief Constable of Greater Manchester Police. It's a 2008 case. I would refer you to paragraphs 18 and 30 in particular. But in that case, the court, considering the two cross appeals on the issue of seized cash, the court found that the onus on the police to seek the further detention is only to allow further investigation as to the origin of the monies seized. At any time during that process, it is open to the person from whom the cash is seized to prove the legitimate origins of the money and have the detention come to an end under Section 109 of your legislation. Thus, there was no need for the magistrate at that stage to be satisfied that the money was in fact subject to forfeiture. Only the further information was required to make any such decision, and in the meantime, hold on to the funds. In paragraph 27, and in the judgment of McKay J., who was one of the justices who made the determination in this appeal, he stressed that at this interim stage for application for further detention, all that he has to show, and that is the person, the applicant, that is reasonable grounds to suspect that this money was in the company's hands because the illegal labor whose services were available to it as a result of a series of criminal acts by it, and who represented roughly half of the workforce on the day of seizure, had made a material contribution to its acquisition. If the company wished to challenge that at the forfeiture stage, it will be able to do so. If they wish to do so at the interim stage, then they have a burden of proof to discharge to the civil standard to show that there's no basis in law on which the money could reasonably be suspected of having been obtained through criminal conduct. The district judge was therefore not asking himself the right question, and this is the right question, whether there were reasonable grounds for suspecting that this money derived to a material degree from the labor of people whom it was a criminal offense to employ, and whether its further detention was justified pending investigation of its derivation or consideration was given to bring proceedings against any person for an offense with which the cash is connected. So, as I said, at the further detention stage, the only question you have to answer for yourself based on the information, and don't be afraid to tell those individuals who are leading the application, you have not brought anything to me in which I can sink my teeth in and exercise my discretion to extend this detention. Don't be afraid to tell them. I have told them, and there have been matters in which I have actually had to, when civil asset recovery, strike out freezing orders, etc., because of lack of information before the court. So don't be afraid to tell them you haven't given me sufficient information, but all they have to show you is that there is sufficient something there. There's something there that requires further investigation. This is what we have done up to this point to investigate the issue, and we just need a little bit more time. That is all that they have to show you. So, and so they have to show that notice has properly been given to the individual who is affected by the further detention, that's section 107.5, that the money has been placed in an interest-bearing account pursuant to section 108. As you will know that, and you will see from the legislation, failure to do so, there will then it means that if in fact if they do apply for forfeiture and forfeiture is not granted and the money has not been paid in the interest-bearing account, that person who has been deprived of the money can now seek compensation from the state for the failure to do so. And that is under section 114. So this is my little flow chart. I hope you can see it. That it starts. Time begins to run as soon as the money is seized. Time is counted as hours. That is why it's stated as hours. Do not convert it to days. That the further detention application has been made before the time expires or there's no proper detention at all. And that point, there's nothing to be extended. It has gone and there's nothing to be extended. Again, don't be afraid to tell the prosecutors and the state attorneys would like to get up and say this is not fair and it's in the interest of. You can talk till the cows come home about the interests of justice. It's not fair to the state. They can even raise issues of the fact that the individual may have had previous convictions, etc. At this stage, it does not make any difference because you are not making a determination as to whether the money will be forfeited, but whether it should be continued to be detained while they make the investigation. So you as a judicial officer have to be satisfied on the evidence before you that they have had reasonable belief to suspect, to show that investigations have been done. As I said, to more information, the better. So if they sent a letter to their friends in Tortola or Bahamas for information on a particular individual, tell them, where's the letter that says so? You can't just make bare and bald assertions either. And then ensure that it is clear that all necessary steps have been taken in terms of notice and deposit of the funds. In the end of the day, we as judicial officers, we are depriving someone of their property. There are a plethora of cases in relation to the constitutionality of this sort of legislation. It is now, I think, quite settled that there's no, it does not contravene the Constitution. But that being said, does not mean that we can act without proper basis when we are being asked to make those orders for further detention. So the applications have to be done quickly. they have to be done transparently, and they have to be done thoroughly. So as a judicial officer, it is your lot to make sure that when it comes to the further detention, that things are as they should be, and then that you feel justified in making that order. And that is the end of my presentation. Thank you very much. And I will have, if there are any questions in relation to what I have said this afternoon, I would hear them now. Thank you.
Thank you very much, Justice Byer. So we'll now open up the floor to questions.
Can I ask a question myself? I know under the legislation, it is the magistrates who would make these sorts of orders and have these kind of considerations before them. Any of the magistrates who are presently here in this session, have you had these applications being made to you in terms of having to make those determinations? Certainly up to this point in terms of further detention before you even go on to the question of forfeiture. Hello?
Sorry, no, I have not had any myself. The applications that we've had have, the last one I dealt with was actually consented to by the party. So even before, when the Crown made the application, he went straight to consenting, indicating that the money had been gotten through unlawful means, and that was the end of the matter.
That's interesting. So he didn't even fight the fact that this money didn't belong to him and it should not be forfeited.
No, in fact, he had counsel, and I think it was suggested that he had other charges of unlawful entry, and he had admitted that the money had come from unlawful means. So it was, we took evidence, we were taking evidence actually, and we continued to take evidence from the officer. And then he indicated in his answer that through his attorney the questions that yes, it's correct, and he consented to the application. Well, it wasn't entered as a consent order, it was just entered that the money stood to be forfeited.
Right. Okay, interesting. Yes, Mrs. Watson-Bonner?
Thank you very much, Justice Byer. In Jamaica, when we initially started the cash seizure, when the provisions came into effect, we too would have a lot of uncontested applications, and as such, in those times, then the state would benefit significantly from the recovery of cash. Once the provisions became a little bit more seasoned, and defense counsel became more au fait with the provisions, then they started we started to face significant challenges, and that is when we started to build the body of law around cash seizures and what would obtain. Another thing that used to happen is that our police officers would initially, because police officers and customs officers are authorized officers, and initially, based on the wording of the law, they were the ones who would go to make the applications before the magistrates, which were substantially unchallenged. Once we got to the stage where the body of law was developing, then we could no longer have police officers and custom officers appear before the court, because judges were no longer prepared to hear them. Defense counsel was no longer prepared to appear against them, because I'm not appearing against someone who is not a police, who is not another attorney of equal counsel. And if the matter went before appeal, how would you now answer questions of law when you get to that stage? It's very interesting, but it's early days for them too. But we saw some of those things at the initial stages of our proceeds of crimes provision relative to cash forfeiture, cash recovery.
Okay, that's very interesting. What I am seeing, and I mean, I am sitting in the OECS, and I've sat now this is the third jurisdiction in the last 11 years. And I was just having a conversation with the magistrate, one of the magistrates here in Antigua, who said just last week she had a trial on the issue of cash forfeiture. But I find that it is still in such nascent stages in a lot of jurisdictions where it doesn't appear to be quite understood that what is exactly can be done by those persons who are on the front line. That's the police officers, the customs officers / immigration officers, depending on the jurisdiction. And I mean, I was hearing some stories in terms of TCI monies being seized in certain circumstances and then being given back to the individuals. So it is, as judicial officers, I think we really have to understand that and give the, what's the word I want? Like the backbone to those individuals who are on the front line and understand what is our role and function in the whole system. But that is interesting in terms that a lot of people are at least in the initial stages of this, and in terms of certainly what Magistrate Hatman has just indicated, the consent positions. So I think that obviously answers my question that certainly in the TCI, it is probably still in very nascent stages in terms of these matters coming before the court. So it needs to have some more, certainly some more interaction between all parties to see how can this be made more effective. Are there any more questions or comments in terms of what I have indicated today?
I have one question, Justice Byer.
Yes.
All right, so for example, the 72 hours has expired and the police would know that they have to release the cash. So they would release it and immediately reseize it. Would that be considered abuse of process?
It depends on the circumstances, but I would say at first blush, it would. But there are also provisions where if one, okay, so like say customs has seized the proceeds, the cash, they are not dealing with it, they've released it, and then the police can then subsequently seize it again for their purposes. So it really depends on the circumstances. If it is, I would say, certainly if it is that they have allowed the 72 hours to elapse and have done nothing, and then allow it to be released and then reseize it, then there can be a very good argument. And I believe I saw Mr. Clement Joseph on this meeting today, and I know he will not agree with me, but
I plead the fifth.
I know that would be the practice of enforcement officers. So
yes, and I think there would be a very good argument for there having been an abusive process. But again, it would depend on the circumstances, depending if it's two different agencies who have done it and in the circumstances of how that's happened. Yes, Mrs. Bonner?
thank you.
Just to add to the point, Judge, that again, and I can only use my Jamaican experience.
Of course.
At the initial stage again, our officers would use 72 hours to mean 3 days. And the very fine distinction of the ex parte Uxbridge came to be heavily relied on in the jurisdiction amongst our magistrates, because we had to appreciate that 72 hours was not 3 days. And so we had some matters where the cash had to be released in those circumstances. And it is to be separated from circumstances where an officer is allowed to reseize.
Right.
You're not getting a second bite at the cherry where you have failed on the basis that you are out of time. And the point you've made in relation to the circumstances under which the cash was held initially and the fact of reseizure is different from an officer, that the time having expired due to your whatever action, whether it was evil or good intentions, but the time expired. it is very strictly interpreted and very strictly applied by the court in the circumstances. Yes.
Yeah, quite so. Any further comments, questions? If not, I will say thank you so much for giving me this opportunity to present to the judicial officers and all other parties this afternoon. And thank you very much. Back to you, Mr. Emmanuel.
Thank you very much, Justice Byer. So I'd now like to hand this over to Ms. Tanya Carter, the Executive Director of the Office of the Chief Justice, who will give a formal vote of thanks.
Good afternoon, everyone. On behalf of the JEI of the Judiciary of the Turks and Caicos Islands, we wish to thank all presenters today, Mrs. Joanne Xavier Cuffy, Ms. Kisha Sutherland, and Mr. Alan Alexander, Mrs. Suzanne Watson-Bonner, Justice Nicola Byer, and lastly, but by no means least of them all, Mr. Clement Joseph, for creating the liaisons and the contacts to be able to facilitate today's training. Each presentation and the various topics, from legislative overview to detention and seizure to cash forfeiture and further detention, was quite informative, detailed, and all had very engaging deliveries and presentations. So we thank once again each presenter. Certainly, our judicial officers here are appreciative of the manner in which each of the presentations was set out, and which we know will ably assist, reinforce, or provide guidance on what they need to consider in the conduct and exercise of their duties when treating with matters of this nature. So once again, on behalf of the JEI of the Judiciary of the Turks and Caicos Islands, we say thank you to everyone. I now hand it back over to Mr. Emmanuel, the Secretary of the JEI.
Okay, thank you very much. And that brings today's presentation to an end. So thank you very much and good afternoon, everyone.
Good afternoon. Thank you.
Bye, everyone, and thank
Thank
you
you.
so very much for the opportunity.